Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in both Texas, Virginia, and before the United States Supreme Court, and I'm glad you're here with me today. We are here with our continuing coverage of the Ken Paxton impeachment trial. Ken Paxton is the Texas Attorney General, or not technically, I suppose, at the moment, since he's already been impeached, and under Texas law, he's been removed, but he was elected to be Attorney General. How about that? He is the elected Attorney General, and he has been impeached for various misdeeds related to this guy named Nate Paul. Nate Paul is a real estate guy who apparently fell on hard times in Austin. And the allegation, generally speaking, is that Ken Paxton used his offices to the benefit of Mr. Paul because it is Mr. Paul. Not because it's in the best interest of Texas, not because, he thought that there was some real issue that really required his attention, but because it's Mr. Paul. He was doing it as a favor, as a bribe, as a political favor, as a, whatever. That is sort of the allegation. Corruption of his office. He was using the facilities of his office not for his client, which is Texas, but for Mr. Paul, who is not his client. His client is Texas. So he betrayed his client, and that's always bad as an attorney, right? You can't undermine your client. That's kind of, rule number one. So that's the simple version, right? Ken Paxton's client is Texas. He was serving Nate Paul, not his client. Thus, that would be the bad. That's the easy way to put it, right? All right, great. So we have heard testimony from various people that worked at the Attorney General's office at very high level positions within the Attorney General's office who have commented things that they observed about the Attorney General doing things personally and getting personally involved in ways that the Attorney General doesn't normally get involved. And Mr. Paul is sort of there at every step of the way, right? The Attorney General wants to intercede in this case regarding the Mitty Foundation. Why? Because Mr. Paul is there, right? Mr. Paul is there. The Attorney General wants to personally issue an opinion letter from the Office of the Attorney General. Why? To stay off bankruptcy proceedings because it would benefit Mr. Paul. And so forth and so on, right? These kinds of allegations that he did things to benefit Mr. Paul. Signing a contract in order to hire an attorney. Why? To benefit Mr. Paul. All these things to benefit Mr. Paul. So that is sort of the generalized allegations we've heard. And the generalized consensus I've come to so far is that there's a lot of technical deficiencies in sort of the allegations. So I think this is one of those possibilities where two things can be true at the same time, at least in possibility. Right? I think it's true that the people in the Attorney General's office saw some things that they thought was wrong, were being asked to do things that they themselves were professionally uncomfortable with, which as a professional, I totally understand, right? They themselves took oaths to Texas, and Texas is, of course, the client, for them just as much as the Attorney General. So they're like, you're asking us to do things that we don't believe is in the interest of the client, and we're not going to do it, and it makes us so unprofessionally uncomfortable, we're going to be like, no. This I understand to a large degree. So, I get it. I get it. I get partly where they're coming from. I understand. I can understand being in that position. I can understand being in a position where you're like, I have to tell my boss no because it makes me so uncomfortable. I don't feel comfortable doing that. And my professional reputation and integrity is also a little bit on the line here. So I get it. And also they saw enough things that they thought there was a problem and reported it to the FBI. This, at least in principle, I understand. But in terms of the impeachment charges themselves, there seems to be a lot of technical deficiencies, which is the problem of the House managers and how they wrote the thing, which isn't my problem. Right? I'm just here to analyze the charges that they brought. Like, here's the charges you brought. I see some technical problems in sort of these things. It's not really working. And also, the House managers have yet to lay out information as to some of the charges at all. We've heard nothing about the hiring of the mistress by Nate Paul. We've heard nothing relating to that and how that relates to any sort of political bribe. We've heard nothing relating to other charges, so we're still, pressing on with things. So that's where we're sitting. The best charge against Ken Paxton at this time still has to be in relation to the whistleblower, which I believe is article of impeachment number 6. That is the most proven of the articles of impeachment, is that Ken Paxton retaliated against these people for being whistleblowers, which is illegal. He fired them or otherwise disciplined them or otherwise retaliated against them because they're whistleblowers. That is the best allegation. Now, the defense has certainly laid out evidence that all these people had problems within the office, and Ken Paxton might have had reasons to fire or demote or otherwise, take actions against these people. But then it becomes a question of fact. What is the real reason? What is the real reason, right? Here's a bucket of possible things. Like, here's a whole bucket of possibilities. Ken Paxton did it because they were insubordinate. Ken Paxton did it because they were fighting him. Ken Paxton did it because he no longer trusts them. Ken Paxton did it for any number of other legal reasons versus Ken Paxton did it because they're whistleblowers. Like, all the other reasons are legal, because they're whistleblowers is not legal. So which is it? And as I sort of commented yesterday, the timing of it and the fact that it happened to all of them is much more suggestive, at least in my humble opinion, as a matter of fact, that it is because they're whistleblowers, right? He might have had reasons to discipline them. He might have had reasons to fire them. He might have had reasons to do what he did, but he didn't do it before they went to the FBI. He only did it after they went to the FBI, and he did it against all of them. And that seems much more like a retaliatory move, right? For any single one of them, you could probably argue the other way. It is the combination. It's this one of those things, like, you can only explain away so many things before you run into a problem. Like, you can only explain so many things. And once you explain too many things, you kind of have a problem, and Ken Paxton has a problem. Now, that isn't to say that I don't think he can rebut that. They've already teed out the possibilities that they have, right? They've already teed out the possibilities that Ken Paxton did it for other reasons. So he can rebut it, but right now that's the best charge against him. So, and other charges are completely unproven. So that is where we're sitting right now, at least in this commentator's humble opinion. So that is where we are sitting on all that. Thank you for Vanessa for saying that you like my shirt. I am very happy. And we'll also try to ignore this blemish on my face throughout the day. I've tried concealer and we'll try. Nunya Business says, unless they knew what was coming and ran to the FBI. Yeah, that's the question is, what is Ken Paxton's reason? Right? So what is his reason? Would he have done it? Would he have done it anyway? Or not? Or was it a factor, right? Was it a factor? Right? So if you like, it's equivalent to firing someone because of race, or it's equivalent to firing someone because of religion, or it's equivalent to firing someone because they're too old, or it's equivalent to firing someone because of other protected reasons, right? What is the real reason? What is the real reason? Did you do it for these protected reasons, or did you do it for other reasons? And that's the question of fact. And then it's just a question of how do you assess it. And at least in my humble opinion, so far Ken Paxton is on the negative end of the whistleblower charge. But that isn't to say that he can't win it. The defense has already teed out possibilities in the cross. And, during their case in chief, one would expect them to bring that even more home. They haven't presented any evidence, of course, yet, because it hasn't been their turn. So we haven't heard any evidence from the defense. We've just heard, the groundwork for what we expect to be evidence in the future. They're laying out all these markers along the road that suggest that there are places for them to fill in. So that's what we're sort of waiting for in sort of that domain. MD says hiring and firing at will is not illegal. Once again, if it's for a protected reason, you can't fire them at will or otherwise. You can fire them for any reason except... yeah, you can fire them for any reason except at will does not solve this problem. At will does not allow you to fire someone for race. At will does not allow you to fire someone for religion. At will does not allow you to fire someone for being too old. At will does not allow you to fire someone for being a whistleblower. At will does not solve this problem. There are certain protected reasons you can't fire someone. Similarly, by the way, it would be similar to a place of business, right? When it comes to the Civil Rights Act, if you want another comparison, right? Do you have the right as a business to refuse service to a customer? Sure, you do. For any reason except, right? So can you throw the person out the door and tell them to never come back? Yes, unless ... right? That's the situation that we're in. So one more person says at will, I'm going to lose my mind. One more person says at will, I'm going to lose my mind. Also, not for nothing, because they're governmental employees, I'm not even sure at will, to be strictly speaking, true, because it's a governmental role. It probably is a property interest within the meaning of the Fifth Amendment. So they probably can't be fired at will either, but let's ignore that issue for the moment because that's just way too complicated for our moment. So if it comes up, we'll discuss it later. But because they're governmental employees, yeah, probably not at will either. So, yeah, we'll press on. Isn't there an HR department that say whether it's okay to fire them or not, and maybe know when they went to the FBI? The HR department doesn't make it true. And also, Ken Paxton is the AG. Remember, that's like one of their things in the case. So is there an HR department? Maybe, maybe not. But then, of course, as we've sort of discussed, Ken Paxton is the AG. He's the guy. And as has been laid out quite correctly, like all these people are but fractions of his power. So, I don't know whether or not some HR department signed off on this. Also, I don't care. Because just because an HR department says it doesn't make it true. If it did, no one would be able to sue for wrongful termination ever. Because, of course, every HR department in the world is going to say, well, of course our employer did it for good reasons. They did it for the best reasons. Our company is best company. So HR doesn't magically make it so. Yeah. Yeah. Wishing doesn't make it so. HR can help you. HR can advise you. But if you do an illegal thing, well, you did an illegal thing. So, yeah. I'm trying to be in good spirits. We try to give good legal information over here. But like you just have to accept. It's like you could have debates about some things, right? You could disagree with me about what you think the facts prove. That's fine. But I, as judge, right, I'm going to tell you the law, right? You can be the judge of the facts if you like. But I'm the judge, and I'm telling you, all right, as a matter of law, all right, at will does come with exceptions. It's law. Amazingly, there are asterisks. What a surprise. What a surprise. Can I fire this guy at will? It depends. Wow. There's an answer you've never heard from a lawyer before, right? So, I'm telling you, as a matter of law, this is the reality. He can't fire them because of whistleblower. Now, whether he did that or not is a question of fact. in which you're more than able to opine and disagree with me. But you can't disagree with the underlying premise that he can't. All right? So that's where I draw the line on this thing. Yeah. No, it's fine, Sandy. I understand. I understand. I'm trying to be gracious. I'm trying to be gracious. It's kind of like the song, I would do anything for love, but I won't do that. So in the same vein, you can fire him for any reason except that. Oh yeah. As the new I can't believe I'm going to do this, but that's fine. As the New Mexico governor recently pointed out, sometimes things are not absolute. As the New Mexico governor recently opined, there are very little absolutes in law. That's great. The New Mexico governor is hilarious. Joan asked your question about having charges against him for years which have never been brought to trial. That part I don't understand either. The guy is a goddamn magician is all I can say. How it's possible he's been under indictment since 2015 for securities fraud and it still hasn't gone to trial, I don't know. He must be a goddamn magician. So as to how that's possible, I can't speak to that issue. Because that is, I don't know. I don't know how you keep something out of court for 8 years. I don't know how you do that. That's a lot. I can tell you the Texas Supreme Court recently ruled that the case can go forward in Harris County. So they finally figured out venue. It only took 8 years to figure out venue. Lord have mercy. Does whistleblower protection rely on some good faith basis? Yeah, strictly speaking, but I think they had it, to be honest. Good faith can be mistaken. Good faith doesn't require you to be right in fact. And I generally believe them that they saw things and they thought that something was rotten and abnormal and they saw Mr. Paul sort of behind everything or, in the background of everything. And they thought that, something was really, really wrong because Mr. Paul isn't the client. And why is the Attorney General going out of his way to help Mr. Paul when there is no benefit to the client, Texas? And so, I generally believe, and they said, okay, something is wrong here. Mr. Paul's in the background of something. So the idea that it's because of corruption is a pretty reasonable assumption. It's a pretty reasonable conclusion. It must be that he's getting blackmailed. It must be that he's getting bribed. It must be insert other corrupt reason is a pretty reasonable assumption. It's enough to make a complaint to the FBI, in my humble opinion. Now, whether or not they should is a whole nother set of problems, but are they legally protected? Yeah, I think so. I think they had a good faith basis. Good faith basis doesn't necessarily require you to be particularly well informed. It just requires you to believe something in good faith, and I think they've justified that. which is all this kind of like two things can be true at the same time idea that we've talked about, right? These are not necessarily mutually exclusive propositions because, of course, as always, when we're talking about law, we have to put ourselves within the right vantage point, the right frame of reference. So you don't necessarily have to conclude like one or the other. You could conclude both. You could reasonably conclude these people acted in good faith and also simultaneously conclude, at least in principle, that Ken Paxton did nothing wrong. These are not mutually exclusive propositions, right? It would be, I don't know what the analogy would be. It would be akin to, I don't know, you being in an apartment complex and you see like smoke coming out of your apartment neighbor's door and you call the fire department, but it's just because they're a lousy cook, not because the place is on fire. So like, did you see a problem? Yes. Were you right to call 911? Yes. Was there in fact something wrong? No. So both things can be true at the same time, at least in principle. So it doesn't necessarily, now of course you can obviously conclude they're not acting in good faith. You could obviously conclude that they did it, merely to like shield their jobs, and their real motivations in making the report was not something that they thought something was wrong. Their real motivation was they were trying to prevent from getting canned. You could conclude it wasn't in good faith, but at least so far I've concluded it's in good faith. Which, fair enough. But that question is not dispositive as to Paxton. So, it also isn't as positive as to what Ken Paxton believed, of course. Whether or not they were acting in good faith doesn't necessarily go to Ken Paxton's belief about the whole thing. Everything has to be viewed within its own frame of reference. I think maybe that's the most complicated thing for some people in law, is switching vantage points and switching frames of reference. We dealt with this a little bit like when we were talking about Kyle Rittenhouse back in the day, and we were trying to go through various vantage points and like, okay, what is true from Kyle Rittenhouse's viewpoint? What is true from Groskowitz's viewpoint? What is true from Huber's viewpoint? What is true from this person's viewpoint? Right? What are their viewpoints? And what would the evidence, and trying to analyze things within various frames of reference. So I think maybe, and I think, sometimes people forget that, just because one person knows a thing doesn't mean that everyone knows the thing. Different people have different knowledge bases, different information, different beliefs. So maybe I think that might be one of the more complicated things, is just keeping the frames of reference straight. Do the New Mexico police have authority to arrest the governor? Probably not, but they can ignore her direction. I'm not sure that what she did is an arrestable offense, but they can ignore the direction as illegal. But then again, like, that gets into the whole thing, right? So this is like a good example, a case in point, right? This is a whole issue, and things get obviously complicated. But like, okay, this is a good example. It's like, can the police refuse the direction of the New Mexico governor? Well, she is the governor, right? She is the person at the top of the food chains. So maybe them refusing the direction is just insubordination. And you say, no, it's not insubordination because they took an oath. And this is illegal. It's an illegal order. And it's like, right. That's true. And then, like, going back to our current frame of reference, right? If these people really believed that the order was illegal, if these people really believed that what they were being told to do was illegal, then their insubordination looks a lot more justifiable now, doesn't it? Because now they're refusing what they believe to be an unlawful order. And it's not military. So you don't have to worry about, from that vantage point. But like, should the police refuse the New Mexico governor's order is a little bit like asking, should these people refuse the attorney general's order? Is that mere insubordination, or is it really upholding your own oath? Right? So, if you believe that the police should refuse the New Mexico governor's order, then you have to at least accept the possibility that these people were potentially right in refusing the attorney general's order. It's like, unless you think, that they are just bound to obey the order, in which case you also would presumably think the New Mexico police should obey the New Mexico's governor's orders. Like, how do you want it, right? TMF says they're not sworn LEOs. They're sworn. They're not LEOs, that's true, but they are sworn to uphold the Constitution of Texas and the United States. So, I'm not sure the distinction is as great as you would indicate. Two entirely different scenarios? I don't think it really is. Right? In principle, it's not. In fact, maybe it's a little bit different, but in both cases, you arguably have a inferior rejecting the order of the superior for what they believe, because they believe the order of the superior is illegal. So I'm not sure it's as incomparable as you're suggesting. Now, maybe the nature of the illegality is more obvious in the case of the New Mexico governor, so maybe it's different in that way. But just because it's more subtle doesn't necessarily make it more legal. Do they have arrestable powers, the people at the AG's office? No, they don't. So the nature of theirs would not be in refusing to arrest somebody. The nature of theirs would be in refusing to carry out the directions of the AG's office because they would believe it's be illegal. I'm not sure the power to arrest makes this magically different. Right? No, you've ordered me to do an illegal thing. I'm not going to do that legal document. Right? So I'm not sure the power to arrest really changes this analysis very much. It would depend on if there's independent authority. That's true. It's a fair point, at least in part. Kyle says, has it been established that Paxton knew they went to the FBI when he fired them? Yes, I believe so, because they themselves said they told Paxton the day after they went to the FBI. So Paxton knew at the time that he arguably took the conduct against them. Yeah. Yeah, so the sheriffs are independently elected. So yes, the analogy does break down a little bit. Because they're independently elected, so they're not subordinates of the governor. So the analogy does break down a little bit, but I still think the point is valid despite the difference. It's like you have people openly defying the governor, and so they're doing it because they believe what the governor's doing is illegal. So there's some comparability, I think. So I don't know. I'm sticking with the analogy, and we'll press on, I suppose. Like all analogies, it breaks down at some point. The question is, of course, does the analogy work for the point? And I think it does. To the 426 of you who are currently here, by the way, thank you and good morning for being with us. I appreciate every one of you who is here. I'm in good spirits, and I hope you are too, as we try to analyze this case and assess it for its merits, as always, trying to keep an open mind as to the facts and trying to listen to the witnesses and trying to assess things. And I appreciate that you're here, and you may assess things differently. That's okay, because we're going to look at the facts a little bit differently, which is okay. That's in the nature of the thing as we try to assess facts. But I appreciate that you're here and here with me to try to assess along with me. Jules Buddha is here, $20. 20 gift memberships. Thank you very much. We do appreciate everyone who gives memberships to the channel. And if you hit that beautiful, beautiful join button, it would be appreciated. Also, if you don't have any money, you can also retweet the pinned link, And that would be very helpful because anything to help get knowledge of the stream out. So if you could retweet the pinned link in the chat or share it otherwise on your social media of choice, tell your friends, that would be helpful. Also, it should be said, as we sort of said yesterday, that a lot of the witnesses yesterday were kind of a waste of time for the prosecution. They didn't really do anything. It also kind of shot their case a little bit in the foot. Like, they called the elected district attorney of Travis County to the stand, the prosecution did. And then we found out that the elected attorney's office, let me rephrase, that the attorney, apologize, let me try one more time, that the district attorney's office of Travis County issued the grand jury subpoenas for the attorney that was working for the attorney general's office. They're the ones that issued them. And their paperwork says special prosecutor on it, which isn't language that came from the attorney general's office. So it appears that basically the Travis County district attorney essentially appointed him as a special prosecutor. I mean, it didn't go through the process. Some of their subordinates just magically did it. But yeah. So the idea that Ken Paxton caused these things to be issued, yeah, not so much. The charge against him as to that kind of went away. So that was a brilliant moment. We called some assistant district attorney to the stand to say, here's a whole bunch of things that he might have done illegal, which, okay, why? Why are we calling this guy to stand, and what value does he have? I don't know. And then we also heard from a woman in the office who had been there a long time, and she seemed to be there just to offer character attack. She was there just merely to, like, bring in the fact again that he's an adulterer, which doesn't have much to do with anything. And information we already had, incidentally, but she was there, I guess, to emphasize it and be like how disappointed she was and how disappointed the staff is. But she's not there to judge, mind you. She doesn't have any interest in whether people have affairs. Her only interest is the office. Sure it is. So we had sorts of problems all over the place about things. We had sorts of problems all over the place about things. So yesterday there was a lot of wasted time. She has nothing to offer. She retired. Ken Paxton didn't retaliate against her. She had nothing to offer. It was a waste of time. So we had 3 witnesses yesterday that were kind of a waste of time. If you're getting ads, by the way, just a friendly reminder that you can and probably should install an ad blocker on your browser. I use uBlock Origin, so I recommend that, I suppose. So you know, get an ad blocker would be great. Or of course you can pay for YouTube Red, which I do, but you know, that's me. Alex McMecken gifted 10 gift memberships. Thank you very much. Jargon says, I declare bankruptcy. That's definitely not how that works. Thank you for the super chat. Automatas gave $5 to say, why do they keep undercutting their perception of his corruption with his mistrust of law enforcement? That's an alternative that's not reportable. Yeah. The Chugi Show Live gave $4.99 say, do the New Mexico police have authority to decide to arrest the governor, or do they need a judge to issue an arrest warrant? People on X are like, arrest her. I'm not sure that's possible. Burger King 23 gave $10 and then just chatted $10, which also is appreciated. Thank you very much. We do appreciate everyone who helps to support the channel. We always aim to give you good analysis on this channel. It's McMeekin. Alex Meekin, thank you very much for your support. So we do appreciate everyone who helps to support the channel and makes this possible. Viewers like you. Raphael says, all the testimony reveals a lot of office screw-ups. Does it look normal for any workplace? Yes. Yeah. I think it's pretty normal in my experience. You know, you get a large enough group of people together, and this is kind of normal in some ways. That was a PBS reference, yes. Where's the free tote bag? Yeah, give me a $500 super chat. I'll figure something out. I'll send you a tote bag. I'll get one made with an Uncivil Law logo. I don't know. I'll figure something else. Did the FBI find any wrongdoing? Not that the FBI has told us about, no. The FBI has not illuminated us with any knowledge. If I had to pick a charge that would stick, we've discussed that. Number 6. Firing them for being whistleblowers is by far and away the best charge so far. We still don't have evidence as to some of the charges, and other charges are falling apart legally. You know? Like the Attorney General's letter, their opinion. It's like, it's not an opinion. It's like, first of all, it says not an opinion right on the cover of the thing. So it says right on its own terms, this is not an official opinion. So there's that. And then as the defense pointed out, it does not also meet the statutory standard for being an official opinion because it doesn't meet the statute. So that's a real legal problem. It doesn't meet the statute. It says it's not, and it also doesn't meet the elements of the statute. So it's kind of a problem. Did anyone testify Paxton knew they went to the FBI? Yes. They said that they told Paxton the day after they went to the FBI. They told him. It was either the day of or the day after. They said they told him. So Paxton knew. What would the second charge be then? What is the best after that? Okay, let's take a quick look at the impeachment articles and see what's best in running. Let's take a look. Take a look. It's in a book. Reading Rainbow. What is second best charge right now? I can do anything. Let's take a look. We haven't heard any testimony that Paxton harmed the Mitty Foundation, really. We haven't heard anyone from the Mitty Foundation. So charge 1 isn't really viable. Abuse of official opinion process. We haven't heard about the straw requester. Abuse of open records process. He gave a no opinion letter, which seems kind of eh. Misuse of official information. No. Engagement of Carmack. Maybe. Article 5. Paxton engaged Brandon Kamak, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamak issued more than 30 grand jury subpoenas, although they came from the Travis County office, so he didn't issue them. So that's a problem. But let's say 5, and if we, squint, sure. Article 6, maybe, directing the employees of his office to conduct a sham investigation into the whistleblower complaints and create and publish a lengthy written report, although we haven't really heard enough testimony about that, but that's still viable. The settlement agreement, employment of mistress, we've heard no evidence about. Constitutional bribery is a little thin. Abuse of judicial process, no. 12, abuse of judicial process, no. Oh, those not even pending right now anyway, so I can skip that completely. Multiple false or misleading statements in a lengthy report. We haven't heard of that, evidence of that. Conspiracy, we really haven't heard that. So I guess if I had to say what the second most charge is right now, I guess I'd say Article 7 for the public resource for the whistleblower investigation, or maybe Article 5 for engagement of COMAC, but both of which need further development at best. So that's, yeah. One charge is legally sufficient. But of course, it is in the end a political call. So, you could conclude I think technically speaking, they do vote on it as a separate issue. If I remember them reading the rules correctly, I believe the senators vote both as to whether or not there's a violation of both whether or not he's guilty, and also vote separately as to whether or not they should do anything about it. So I suppose you could split the difference there. But I would like to hear more information about the whistleblower investigation report. I'd like to hear more information about See, COMAC didn't issue the grand jury subpoenas. Or did he? I mean, technically. Article 5 is like splitting a legal hair on that one. But then again, it is a question of law. So, Article 5 may not be viable. Did COMAC technically issue them? All he did was sign them at the end, but does that count? I don't... COMAC also represented himself as an OAG special prosecutor. I'm not sure he did. So that's sort of where we're sitting at the moment. Are we going to call the mistress to the stand? I suppose Nate Paul's not going to be called to the stand. I guess he's probably pled the fifth, I would imagine. Why aren't we calling the mistress to the stand? Does she have criminal exposure in all this? I'm not sure she necessarily does. I don't know. None of your business says rhinos will vote for the Democrats. I do take a bit of exception to that. That they're necessarily rhinos merely for voting with the Democrats. I don't feel like that's necessarily fair. If you really genuinely believe at the end of the day that he violated the statute, then I'm not sure that necessarily makes you a rhino. Presumably that just makes you principled, if you really believe it. If you vote with the Democrats because you think that that's what the law requires, that doesn't make you a rhino. So I take a bit of exception to that. Let me put it to you this way. I'd be a little bit upset myself if you call me a rhino just because I think that he did something or didn't do something. Right? I call myself a Republican. I consider myself a Republican. I consider myself conservative. If I reach the conclusion at the end of the day that he's guilty, I'd be a little upset if you called me a rhino. Those are words that hurt. I'm a good uncivil. No? I'm more Pollyanna than most? I don't know about that, but okay. If you vote with the Democrats because you hate Trump, well, I would say that you're not voting because of the right reasons. I would say that you're betraying your charge. Your responsibility is your vote should not be based on whether you hate Trump or not. This isn't about Trump. This is about Paxton. My feelings about Trump one way or another should not read on this issue. So if you vote because you hate or like Trump, for that matter, either way is wrong. If you vote to support Paxton because you like Trump, it's wrong. If you vote against Paxton because you don't like Trump, it's wrong. Right? It should be judged under its own terms. Paxton is not Trump. So, there's that. Ruger says I'm more of a statist. Perhaps. Perhaps I'm more of a statist than a rhino. I would say, generally speaking, I'm more institutionalist in general, although conservatives more historically, at least, although I'm perhaps less modernly, but conservatives tend to be more institutionalist. It's one of the things that they're trying to conserve. It tends to be the progressives who want to do away with institutions and conservatives who want to defend the institutions. I mean, at least in a broad historical sense. So I'd say that I am perhaps more institutionalist than perhaps the current Republican zeitgeist. Maybe that's true. I don't know what's going on in the Senate. I don't know what to tell you. I'm just here with you guys as we're pressing on. Just here with you guys, killing time as we're waiting. I also believe in America. I also believe, for example, in the Supreme Court as an institution. I also believe in the Constitution. Is the Constitution itself an institution? If so, then that. I believe in, I believe in America. I believe in America. I tend to have a stronger opinion probably of the Department of Justice than most of this chat does. That's probably true. I have a generally higher opinion of the Department of Justice than I think my chat does as a whole. Their 97% conviction rate is impressive. Impressive, yeah, it certainly is. But it's hard not to have distrust in a lot of institutions. When Anthony Fauci looks you straight in the eye and just lies to you, and then basically admits to the fact that he lied. It's hard not to have distrust in a broader sense. It's hard not to have distrust in things. When you see the FBI or elements within the FBI, doing things that are improper, illegal. When you see the FBI, for example, conducting mass surveillance on hundreds of thousands of Americans to the point where even the FISA court says it was illegal. And when the FISA court says it's illegal, holy shit, it must be really fucked up. So, then you're like, I have a little bit of distrust in the FBI. It's like, it's hard sometimes not to say like, oh yeah, here's the time that they did this thing with Flynn that was pretty fucked up. Here's the time they did the thing with, hundreds of thousands of Americans. That's pretty fucked up. Here's a time that they spied on the Trump campaign. That's kind of fucked up. And then be like, not have some distrust in the institution. It's like, they're not like necessarily baseless for having distrust in the institution. Maybe it's me holding on hope. Maybe my hope has not been crushed before my eyes. It's like, no, it's just a few bad apples. The institution is still good, damn it. I'm holding on. I'm holding on. What's FISA? The Foreign Intelligence Surveillance Act. The Foreign Intelligence Surveillance Court. The FISA court is the court that issues warrants for, ostensibly, for spies. So if the FBI believes that a person is a spy, they get a warrant from the FISA court. Its proceedings are secret. It's not exactly a secret court, but its proceedings are secret. And what was the exact number? Let me see if I can find the article. Yeah. So the FISA court issued a public opinion, which is pretty rare for the FISA court because they're a secret court. So they don't issue a lot of, well, no, again, they're not a secret court. It's just their proceedings are secret. So they issued an opinion in 2020 that said that the FBI conducted 278,000 improper FISA searches in 2020 and early 2021. So 300,000 improper searches by the FBI in a year. And that's basically what the FISA court can prove. Right? That's where it's so obvious that they're like, yep, that was illegal. So the real number's probably higher than that, right? So, yeah. So, yeah, the FBI only spied illegally 300,000 times in a year. So, that could raise some questions in the institution. So things like that. And I don't know what the Senate is doing. They're still mulling around, and they're almost an hour late. But that's okay. We can talk about other things while we're waiting. Starscream 1540 says, "Hi Kurt, I trust your analysis, but I don't have enough time to watch all your live streams. Can you do a video highlight for the Ken Paxton impeachment?" Well, I've definitely been clipping out interesting moments and posting those. I mean, I suppose I can try to put together a video trying to summarize my thoughts at the end of this thing. So we'll see what we can do. Thank you for the super chat. Cody Sam says you're bitter about qualified immunity. Yeah, qualified immunity in its current iteration needs legal work. You know, the biggest problem, there are many problems with qualified immunity. I think we should just go back to the reasonable officer standard. What was wrong with the reasonable officer standard? It was perfectly fine. But if we're going to do qualified immunity, the biggest problem with qualified immunity is the fact that it's so hard to get new precedent, right? That's the thing, right? In order to overcome qualified immunity, you need to have a violation of your constitutional rights that's clearly established. So what happens when it's the first time, right? Well, it's not clearly established, so it gets dismissed. So it never gets clearly established, right? The first time it happens, it gets dismissed because it's clearly established. Then it happens again, and it's like, well, it's not clearly established, so it gets dismissed again. And then it happens again, well, it's not clearly established, so it gets dismissed. It never gets clearly established, right? So it's so hard in qualified immunity to get new cases because you have to, like, overcome that, and it's pretty rare. And the courts of appeal technically can issue new rules. They can, but they very rarely do. So sometimes the Court of Appeals will be like, okay, it wasn't clearly established, but going forward, here's the rule. So sometimes they do that, but they don't have to, and they don't do it very often. So you're in this continuous situation where it's not clearly established, and because it's not clearly established, it can't become clearly established. And around we go. It doesn't make any sense. I don't know if cops need qualified immunity. The reasonable officer standard probably would be just fine. You know, what would the reasonably prudent officer do? It's like the same test we use for everything else. It's just the reasonable man test. The reasonable man test is great. You know, what would the reasonably prudent person, the ordinary person, the man on the bus, what would he do? And you just be like, okay, also he's a cop, right? So then you're just into the reasonably prudent officer. What would the reasonably prudent officer, the normal officer, the man on the bus, what would he do? And it's perfectly fine. So would the reasonable officer do X? If so, then great. If not, then that's a problem. So I'm not sure you need qualified immunity. The reasonable man test would probably be just fine. But, you know, that's what I think. I don't see on the Senate's Court of Impeachment page, which I'll give you a link to, but I don't see where the Attorney General's exhibits are. They have the House Manager's exhibits, but I'm not seeing where the Ken Paxton's are. Motion challenging jurors for cause. They filed a motion challenging jurors for cause. That's funny. It's below the House exhibits. I don't see it. Exhibit A and Exhibit B at the very bottom. Is that all that was? Just the two exhibits? Exhibit A and Exhibit B? That can't be right. What are they doing over there in the Senate today? They're not anywhere close to meeting, by the way. They're just, I don't know what they're doing. What are they doing? Is one of their number not there? Is someone sick? Is it a COVID thing? Also, I just think it's interesting that basically no one's in the gallery. Isn't that interesting? No one's there in person? I just find that so interesting. Like, no one is there. Look how empty it is. You would think that this would be a bigger thing, but apparently not. Is there a set number of hours for this trial? Yes. It was 27 hours per side. 1 hour for opening argument, 24 hours for presentation, and I think 2 hours for closing argument. It's 27 hours. And they're both at, what was it yesterday, 12? So we're halfway through. So we have 24 hours left, 3 days worth of coverage left. I have a thing Thursday evening at 7 o'clock, so we may miss some of this, depending on where it goes and sort of time. So we'll see. You thought the House was at 10? I think they're both at even time. So we may miss some of Thursday evenings, depending on how things wrap up. We'll see. Well, we might take a break, I guess, as we're waiting, because there's nothing happening. So I suppose we'll take a break, and I can stretch off. So maybe I'll just go off camera while we're waiting, and you can listen to some music or something. I have chats. I thought I read them all. I think I read them all. $5 from Duncan, Idaho says, Kurt, can you read this chat too? Kurt, can you read this chat, please, too? Yes, I can. Thank you, Rose, for saying I look dapper. That's very kind of you. Feeling dapper. Despite the fact that I'm having obvious skin problems. But that's okay. My efforts at concealer, I put on plenty of concealer and it's still kind of showing through. But that's all right. We'll press on. The house managers have 9 hours. Really? Do I have time to watch movies? My favorite movie of all time is Thank You for Smoking with Aaron Eckhart. That's my favorite movie. It also has Rob Lowe in there, J.K. Simmons. Great movie. Shawshank Redemption, of course, classic. Godfather, overrated. Goodfellas, better movie. Let's see. I've enjoyed the Mission Impossible series. I haven't seen the latest one, though. So that's still on my to-do list. Was the first movie I mentioned Thank You for Smoking? Was the name of the movie. I'll type it in chat. Thank You for Smoking. Good movie. That's my favorite movie. Let's see. Citizen Kane is overrated. I'm trying to think other good movies. I thought I read all the gifts, Sandy. Have I missed any? Rogue Accountant gifted 20 gift memberships. Tina Lewis, 1999, said, I honestly can't help but think this is all about amicus brief Paxton filed after 2020. The impeachment could be out of fear that Paxton could file another one in 2024. If it just becomes a repeat of 2020. I don't know, just guessing. Robert Norwood says, if you have the power to hand down the verdict, what's the current gut feeling on how the trial's going down? As I've already commented, I think that the biggest liability for Paxton thus far is for the firing of the whistleblowers. So that's what I think. Bad Weather Biker gifted $5 and said, good morning, Kurt and Uncivil Law fans. Thanks for making my workday less boring. $5 from a Starscream, who said if I could do a video highlight for the Paxton impeachment trial. And $5 from Duncan, Idaho, who said, can I read the chat? Which I did. So thank you very much for all your super chat and supports. Duncan, Idaho said, I really just want one of my favorite lawyers to watch 1982's The Verdict with Paul Newman. It's a pretty good one. It's been a while, but it's a good movie. Let's see. 12 Angry Men from 1957. Great legal movie. It might be my favorite legal movie. 12 Angry Men from 1957. I admire it also for just the way it's done. Like all but 3 minutes of the movie happen in one room. And that's just kind of cool. Right? There's a very little bit that happens in the courtroom at the start. You know, there's a little tag scene at the end, and there's a little scene where they're talking in a bathroom, but all but 3 minutes of the movie just happened in the jury room, and it's just 12 people talking, and it's incredibly fascinating, and it's just amazing. Like, it's just, how do you make, you know, there's no special effects, there's no music, there's no there's no scene changes. It's just all happening in one room. And it's a good movie. I really like 12 Angry Men. I think it's my favorite legal movie. The Back to the Future trilogy might be the best trilogy ever made. The movie Blow might be my favorite movie with Johnny Depp. Brewster's Millions. Down Periscope. Great comedy movie. Kelsey Grammer. Fight Club. Fantastic movie. Every guy likes that. I think I'm legally obligated to like it. Hacksaw Ridge. Fantastic movie about Private Doss. Medal of Honor winner. Great story. Private Doss, World War II. He's a guy who refused to carry arms. He wanted to be in the military, but he refused to pick up a gun. So he's a conscientious objector inside the military, which is a thing you can do. And it's a great story, right? And at least in the movie, like, they try to court-martial him for refusal to obey a lawful order, but he's protected by an act of Congress, so it's not a lawful order. Like, the lawful order being pick up a gun, and he's like, no. And so they can't court-martial him. And everyone thinks he's a coward and all the rest of it, but then he went on to, like, save so many lives as a combat medic in World War II. And he never fired a shot, and he got the Medal of Honor, and he deserves it. It's a great story. I recommend it quite a lot. Private Doss is a badass, right? He goes right into the heart of battle, no gun, just saves everyone. It's a very interesting story. There's this great movie from 2006 called Inside Man. Denzel Washington, this guy plays a bank robber. And it's a pretty interesting movie. I recommend that. Inside Man. John Wick movies, of course. Everyone loves those. Kill Bill. Mission Impossible series we've discussed. Payback with Mel Gibson. That's a pretty good movie. I recommend that one. Pumping Iron from 1977, Arnold Schwarzenegger. That's pretty interesting. Arnold Schwarzenegger in his heyday, that's a pretty interesting movie. Imitation Game. Dealing with Turing in World War II and the cracking of Enigma. Highly dramatized, but, still fun. The Ninth Gate. That's an interesting one, too. Did I say Blow was my favorite Johnny Depp movie? It might be Ninth Gate. Ninth Gate is a very interesting movie. Very interesting Johnny Depp role. So, Ninth Gate might actually be my favorite Johnny Depp movie. It's a very strange movie, but I like it. Trading Places. Fantastic comedy. Hudsucker Proxy. Underrated. I think Hudsucker Proxy is at least as good as The Big Lebowski, but it doesn't get any love. Those are some of the movies that I have tagged. And of course, James Bond movies. Coming to America is okay. I prefer Trading Places, though. Rainmaker is a fantastic movie. It's a very, very good legal drama. It might be the most accurate legal movie ever made. Sum of All Fears is okay. It's a good movie. A little unrealistic in the end. But, that's fine. Hunt for Red October, I really, really like. Beverly Hills Cop. Beverly Hills Cop is fun. Beverly Hills Cops are fun movies. Didn't like Raising Arizona. I didn't get it though. So, but then again, I didn't get Big Lebowski the first several dozen times I watched it, so yeah. Ghostbusters. I think I prefer Ghostbusters 2 to Ghostbusters 1, but that might be because I saw Ghostbusters 2 first and then saw Ghostbusters 1, so that might be the reason. I have a soft spot in my heart for Die Hard 2. I think I like Die Hard 2 better than most people. With them at the airport and the planes. I like Die Hard 1, 2, and 3. I think they were all pretty good, actually. And then it kind of went downhill from there. I think most people don't like Die Hard 2, that like the Die Hard series, but I kind of like Die Hard 2. Dirty Harry. Dirty Harry's okay. Air Force One? Really? Air Force One is just a silly movie, but fine. Pulp Fiction. Overrated. It's a fine movie, but I think it's overrated. I don't quite think it deserves the level of love it gets, but that's me. Fugitive is good. Snakes on a Plane I saw in the theater when it came out at its first showing. I went to the first showing of Snakes on a Plane. I was following that movie, you know, as it was sort of getting this like buzz at the time. And like people were talking about Snakes on a Plane, Snakes on a Plane. I actually went to go see Snakes on a Plane at its first showing. You know, I think it was 10 o'clock in the evening. And I went to the first showing of Snakes on a Plane, and it was pretty glorious. Stargate series is fantastic. Stargate series is pretty good. I didn't really care for the way it ended. But a lot of the Stargate series was very, very good. Jurassic Park. The special effects for Jurassic Park still hold up all these years later, so that's pretty cool. Stargate is coming back. Okay. Firefly series. I've never actually seen Firefly. I hear good things. But most people who see it say that they're really, really sad that it ended. So I'm like, well, maybe I just won't watch it and then I won't be disappointed.
All rise. The Court of Impeachment of the Texas Senate is now in session. The Honorable Lieutenant Governor and President of the Senate, Dan Patrick, now presiding.
Okay. Let me refresh the page because apparently we've got, you know, mechanical noises.
Good morning, everyone. Bailiff, if you will bring in the jury.
God damn it. Please don't be distorted. Don't do that to Uncivil. Dr. Strangelove? Doctor Who? I don't like Doctor Who. I've seen a couple episodes and I definitely don't get it. So it is not for me. Full Metal Jacket was a fantastic movie. Third Man? That's old school.
Morning, everyone. Will our prayer leader come up to pray? Senator Blanco from El Paso.
Why am I having such audio problems? God damn it.
Let us pray. Heavenly Father, we come before you today with humble hearts, seeking your guidance and your wisdom as we embark on our work.
Let me try reloading a window or something and seeing if I can get the audio to clear up. It's always something on the Uncivil Law, I swear, you know? It's always something.
Hold on to this promise, knowing that you
There we go.
are our source of unwavering courage. Strengthen our resolve to trust in your plan, even when the path before us seems uncertain. We also pray that we may be instruments of your righteousness, discerning right from wrong.
There we go.
And upholding the principles of fairness and equality. Lord, we thank you for being our ever-present help in times of need, and for the wisdom and the grace that you provide. May we walk boldly in your light, knowing that you, by our side, we can conquer all obstacles. We offer this prayer in Jesus' name. Amen.
Thank you, Senator. You may be seated. To the public and to the media and to the members, we are beginning late this morning. The court's always ready at 9 a.m., but both the House and the defense had issues they needed to bring forth to the court, and so we have walked through some of those issues. Can I have both sides come to the bench, please?
Okay. Oh, yeah, old Top Gear with Clark, Hammond, and May. Oh, yeah, huge fan. I've seen every episode of the Top Gear. And I think I've seen every episode of the Grand Tour with them. I love Top Gear. I love Top Gear. We could talk about Top Gear for a while if you like. Top Gear kicked ass. I think my favorite like Top Gear special was Bolivia with the discount 4x4s and trying to go through the jungle. And then I think my favorite segment on Top Gear was an early one. I think it was like series 4 where they did a race between Clarkson and a car and some guy named Mr. Muir who was an amateur marathon enthusiast, And so it was just like a normal day in London, and they had Mr. Murr run the marathon route, and Clarkson try to drive it in a car and see who would get there first, and the car lost because traffic in London is so bad. That might be my favorite one. Dun-na, 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 yeah. Favorite Sean Connery movie? Well, my favorite James Bond is You Only Live Twice. Is that my favorite Sean Connery movie? Maybe. Yeah, maybe. Should we talk about what Star Trek movies I like and don't like? We could do that again. The Rock, baby. The Rock might be good. Is The Rock actually a James Bond movie? I've seen video discussions on whether The Rock is actually a James Bond movie, and the timeline actually works out pretty well. That the Rock is actually just a James Bond movie. It's like, yeah, someone did a video essay on like trying to prove that the lead character in The Rock is actually just James Bond, and the timeline works out pretty well.
We'll bring in Mr. Kamek.
Yeah, there's a good video essay on YouTube that I saw which tried to prove the timeline would make sense within the James Bond universe. Like, okay.
Mr. Kamek, please raise your right hand. Good morning. I do solemnly swear that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God.
The Jackal?
Please take your seat.
Jackal's a fine movie.
And before you begin, I've always been asked by both sides, I meant to do this earlier, the time clock, presentation of the evidence, the House, 9 hours, 19 minutes, and 12 seconds left. 9, 19, and 12 seconds. Respondent, 12 hours, 14 minutes, and 15 seconds left.
All right, you guys were right. It was 9 hours for the House, so I had misheard something or misunderstood something, so you guys were right. So.
Good morning. Fine. Is your microphone on, please, sir?
Can you hear me? Is that better?
That's better.
Okay, good morning.
All right, Mr. Kamek, obviously, but state your name for the record, please.
My name is Brandon Raymond Kamak.
And Mr. Kamek, how old are you?
37, sir.
And as we've gone through this, you're doing really well about leaning forward.
This should be interesting.
Microphone, I think that microphone and this one requires to be pretty close. If you, I sometimes may call it to your attention, but if you can just sort of try to keep it in mind, that would be good.
Okay.
Now, what's your profession?
I'm a lawyer.
And can you take about a minute and a half, if you don't mind, and sort of give us a little bit of your background and experience, whatever got you to where you are now?
Sure. It all started I went to school at University of Houston for my undergrad. I went to University of Houston law school as well. Graduated in 2015. During my time at U of H, I interned for the Public Defender's Office in Harris County. I clerked for the 208th District Court in Harris County for Judge Denise Collins. When I graduated, I went out. My dad, Sam Kamak, is also a criminal defense lawyer. I got out and started working for him. I worked for him for about 3 years, and then went off on my own, and I've been on my own. I guess for the last 5 years now. And then about last year or so, I partnered with Ben Friedman, who's my business partner. We have a criminal and a personal injury docket. I think I've personally, at this point in my career, handled close to 600 cases, probably tried 15 to 20 cases, somewhere in there. Handled appeals up at the Court of Appeals in Houston. I've argued at the Court of Criminal Appeals, and that's what I do. That's how I got here.
All right, fine. When you say you graduated from law school 2015, and I believe you said you're 37?
That's correct.
So did you do something in between undergraduate and law school?
No, I didn't, sir. I just went straight into law school.
Okay. So when you graduated from law school 2015, you were what age?
It's 29.
All right. So I'm still trying to fit back. Ordinarily, you'd be 25 if you went straight for college. Did you do something before college or so?
I went to school for 2 years, and then I started working for my grandfather, Sam Kamak Sr., Sam Kamak II, for his business. And then I just took a few years off, just focused on working and making a living, and then decided to go back to school at my dad's advice.
Gotcha. So your grandfather was in what kind of business?
He was a business owner. He did a variety of things throughout his life, but he was a commercial real estate developer and also owned a mortgage business. And so I worked with him over there.
How long did you work for him?
I was there, I'd say 2 to 3 years or so, and then decided to go back to school.
All right, now, as you're aware, the time frame we generally hear about are events in the year 2020. At that time, how long had you been a lawyer?
About 5 years.
Okay. And by the way, I think congratulations are due. Did you just recently get married?
I got married to my beautiful wife, Terry, on September 2nd,
So you have been married now how long?
A week and a half. We didn't get to do a honeymoon.
And is your wedding one thing that sort of set the time frame as to when you might be available as a witness in this case?
Yes, sir. That's why we didn't. I'm here, so we didn't get the honeymoon. We'll do that next year.
All right. Now, at the time that, let's say in the period of time of August of 2020, you'd been a lawyer about 5 years, is that right?
Yes, sir. That's correct.
Had you had any federal practice at that time?
I believe at that time I was licensed in the Southern District, but my practice was primarily in the county and district court, state court cases.
And was it at that time exclusively criminal?
Yes, sir. Exclusively criminal.
And you've added sort of a personal injury component to it since 2020?
That's correct.
All right. And in your criminal practice, had you ever been a prosecutor?
No, sir.
So had your experience been literally exclusively, as you have described, doing criminal defense work?
That's correct.
So if you hadn't been a prosecutor, is it fair to assume that maybe you had never dealt with issuing grand jury subpoenas or dealing with a grand jury in the role of a prosecutor?
I had never issued grand jury subpoenas as a defense lawyer.
Okay. Now, you probably had prepared packets representing people for a grand jury, urging them that whatever your client's position was, correct?
Yes, sir. We've presented grand jury packets to the grand jury through the DA's office when we turn those over.
All right. Now, at the time, can you tell us when you first got involved in this case now? When did you first hear from someone, and whom was it?
Well, it would actually be on my birthday of 2020, August 22nd. That's when I first knew about Mr. Paxton reaching out to me. I got a call from an unknown number on that day. I think I was out to lunch with some friends or something. And then later that evening, I got a call from a gentleman named Michael Wynn, who I knew through the Rotary Club, and said that Mr. Paxton had reached out to me.
Excuse me, I didn't mean to interrupt on you. Mr. Wynn, was Mr. Wynn already a friend of yours or an acquaintance? Would you describe, as of August of 2020, how would you describe your relationship with Mr. Wynn?
Just an acquaintance. I knew Michael. I've been heavily involved in the Rotary Club, which is a charitable organization. We have a downtown Rotary Club of Houston. I've been involved with charities for like the last 6 years, I think, and he became a member of that year. And then I had worked with Michael. He was a chair of the Houston Bar Association. I was a member, and he had reached out to me, I think, earlier this summer to do a panel on how the courts would conduct business during COVID-19. And so I reached out to Judge Rosenthal, Judge Susan Brown, Kelly Johnson, Judge Jordan, Herb Ritchie, and there was a gentleman from Baker Botts. But we basically did a Zoom panel on how we would conduct business. So that was my only interaction with Mr. Nguyen.
All right. Did you become, as you got to know him, did you become familiar with the fact that he was a former federal prosecutor?
Yes, sir, I did.
And what was your knowledge as to his background at the time of this call that you just described that you got from him?
Well, at that time, I didn't really know much about his background other than just, it was more just like when I would see him in passing, or at a Rotary meeting, how you doing? I didn't really, it wasn't like a friendship or anything like that. I just knew him from those two settings.
Now, you mentioned your father a while ago was and is a lawyer, but at the time that Mr. Nguyen and ultimately the Attorney General reached out to you, were you in a solo practice or were you with your father?
I was in a solo practice at the time.
And did you have a secretary or anybody, or paralegal or anybody helping you?
I had a legal assistant, and I think at that time I maybe had one other lawyer working for me, and my older brother was in law school as well, and I sponsored his bar card as a temporary bar card or something like that.
All right, so that if you got involved into a case that involved potentially a great number of documents, witnesses, et cetera, the support you would have had would have been what?
I don't understand the question.
The support groups, I mean, what kind of legal support would you have had in order to be able to conduct an investigation or something?
Well, the documents that I received just personally to my email.
Okay. Now, tell me the nature of your call from Mr. Nguyen.
Mr. Nguyen had reached out to me and told me that Mr. Paxton was trying to get in touch with me. Didn't really say anything more than that. The call that I had gotten on my birthday from Mr. Paxton was from an unknown number, so there was really no way to call back. And then it wasn't until the next day that I spoke with him.
And so as a date for the jury to have, the date that you spoke with Mr. Paxton was what date?
That would have been August 23rd of 2020.
And by the way, up there, did you have with you, not that you did, but you have the invoice you ultimately sent to the Attorney General's office?
No, sir.
Did you bring it to the stand with you?
No, sir. I don't have anything in front of me.
Do you want or need that as a point of reference for dates? Or if you don't, that's fine. Or would you like to have available a copy in order to periodically check things? It's totally up to you.
I'll take it, sure.
Pardon me?
I'll take it, yes,
okay.
Sir.
Mr. Hardin, this is his bill.
This is Exhibit 227, which I move to introduce if it is not in evidence.
No objection.
Admit Exhibit 227 into evidence.
Now, I'm not going to really regularly be talking to you about this necessarily, but I'm offering it to you as periodically if it helps you plug in some dates.
Okay.
Have you, in our conversations previously, have you sometimes referred to this to make sure you were comfortable with certain dates?
Yes, sir. With respect to the dates, this would be helpful for me to remember.
Right. Now, let's go to the first. By the way, did you learn as you went along, thank you, Stella, that Mr. Nguyen was the one who recommended you to the Attorney General?
Yes, sir. Mr. Paxton told me that when I met him.
All right. So now let's go to that conversation, your first conversation with the then Attorney General, Mr. Paxton. Did you return his call or did he call you?
I believe I returned his call. I returned his call the next day and we spoke, and he asked me to, he said he would, he had gotten my name from Michael Nguyen. I think the words were, my name was dropped in the hat by Michael Nguyen, and I'm looking to hire someone to work on a criminal investigation, and we scheduled a time for me to come out to Austin here to his office.
So, 5-year lawyer, solo practice, what was your reaction?
I mean, I was excited because it was the Attorney General's office, and so I was excited for the opportunity to go out and meet him.
All right. And did you do so?
I did.
And when did you do it?
I believe that was August 26th. Our meeting was on August 26th.
All right. And in the August 26th meeting, hold on just a second. All right, so tell me about that. Did you drive up to Austin or up to here?
Yes, sir. I drove out to Austin.
Did you go anywhere else first?
No, sir. Just came straight to meet.
Straight to the Attorney General's office?
That's correct.
All right, describe for us that meeting.
So I went in, I signed in the front desk, and then I went up to the floor where his office is, and I think I waited around maybe 15 or 20 minutes, and then Mr. Paxton came to the floor, and we went into his office, and then...
All right. Who was in the initial meeting between you and Mr. Paxton?
It was just me and Mr. Paxton in his office.
Do you recall about what time of day you talked to him?
I think that would have been... I don't recall the exact time, but maybe around lunchtime, somewhere in there.
Okay. Now, what did Mr. Paxton say?
So before I got there, he had actually reached out to me like through text messages and said, "Can you bring a resume with you?" And I was like, "Well, I haven't prepared a resume in a long time," but I went ahead and prepared one, and I brought my resume in, and then it was kind of like, our conversation that we're having now. Where are you from? What do you do? Your background. I gave him my resume and just kind of pleasantries. And then he said that he was looking to hire a special prosecutor to investigate a criminal case where potentially there were potential violations of the Texas Penal Code.
And you mentioned special prosecutor. Was that his word?
Yes, sir.
And so, of course, you hadn't been hired at that time, but later when you were, whenever you represented yourself as a special prosecutor, where did that term come from?
Mr. Paxton.
All right. And did he tell you what the role of this special prosecutor he was interviewing you for would be?
No, sir. Not really.
Initially, when he talked about this job, what did you think it was going to entail?
My understanding, this was just an assumption. I was like, well, if I'm going to be hired as a special prosecutor, I would potentially be presenting a case to a jury maybe at some point, or presenting the case to be charged. That was my initial impression.
And he didn't tell you otherwise at that time?
That was, like I said, sir, that was just my assumption of what the job would entail.
All right. And then how long would you estimate you talked to him in this initial meeting in his office?
Roughly 15 or 20 minutes.
Did he express anything, any views about his own staff or why he was hiring somebody from outside?
Yes, sir. He said that he was interviewing multiple people, considering multiple people for the position, and that he couldn't get his own staff would not work on what he wanted them to work on.
All right. They said they would not work on it?
That's correct. And he mentioned that, he just wanted to find out the truth and about what happened.
Okay. Do you recall anything else from the conversation in that initial meeting?
No, sir.
All right. And then what happened after you had this original meeting with him in his office by himself?
He said, I want to introduce you to someone. I obviously knew who Mr. Paxton was. And he said, I want to introduce you to this first assistant, Jeff Mateer, whose office was down the hall. So he walked me over there, and I met with Mr. Mateer in his office, just Mr. Mateer and I.
And now how would you characterize or describe Mr. Mateer's reaction when he came in and introduced you?
It was the same type of conversation, pleasantries, how are you? I gave him my resume. I told him, the conversation kind of didn't really get off the ground much. Just like, I'm here for the special prosecutor, interviewed for the special prosecutor position. And his attitude was kind of like disengaged about it. Knew about it, but didn't really seem interested in it. I'd say, kind of just like it was Mr. Paxton's own deal that he was focused on. It wasn't obviously wasn't an area of focus or concern for Mr. Mateer.
Did it strike you in any way as if his attitude was, so this is Mr. Paxton's deal, he's not that interested in it?
Sustained.
Thank
you. Then you tell me how it did strike you.
I'm sorry, sir.
How did it strike you as to Mr. Mateer's involvement in it?
Just he was very disengaged did not seem interested in it at all, seemed like it was just kind of a side deal that Mr. Paxton was working on. It was his own focus. Mr. Mateer was not focused on it at all.
How long would you think you were in Mr. Mateer's office?
say roughly 20 minutes.
Had Mr. Paxton left you there by yourself with Mr. Mateer?
Yes, sir.
And then what happened after you finished meeting Mr. Mateer?
I went back over to Mr. Paxton's office, and he was in there, just him and I. And I said goodbye, thank you for the opportunity, thanks for calling me up. And he said, okay, we might be in touch with you. So I drove back to Houston.
All right. So how was it left when this was all over in that first meeting?
I'm sorry, how was it left?
How was it left? What was supposed to happen next?
Well, I really didn't know. I mean, I looked at it like, okay, I just interviewed with Mr. Paxton and the first assistant, and so if they want to talk to me, they know how to get in touch with me.
All right. So you left, obviously. What's the next thing that happened in connection with this case?
I got a text message from a gentleman named Mr. Vassar a couple days later, asking me to set up a time to meet with him.
Do you recall the date or so that you got the text message?
That would have been August 26th or 7th, I believe. It was August 28th, maybe. 27th, 28th.
I'm looking down at Exhibit 227, and I notice it looks like the first time you charged was 9/3. So did you choose not to build the state for that first meeting or two when you went up there?
That's correct. And also I'd like to say that's a typo, that 9/3/20 date. The date that I actually went out there for the meeting was 9/4/20. So I made a typo there.
Okay, all right. Now, at the end, once you got back, you got the text from Mr. Vassar, what happened next?
So we scheduled a time to speak on the phone that day. That's what the text message was about. And we got on a call together.
All right. And did you ultimately send a draft, or receive a contract or proposed contract from Mr. Vassar?
Yes, sir. He asked me for my email address on that phone call. And, I told him, this is about the special prosecutor position, and he agreed. And then he said, well, I need your email address. I'm going to be working on a contract for you.
Okay. Did you receive that contract?
So, yes, sir, I did.
When?
Well, I got the contract on 9/3, September 3rd, but I didn't, it must have got lost. I get hundreds of emails that just got lost in the shuffle somewhere. So Mr. Paxton actually reached out to me on 9/3 and said, did you get the contract by text message? And I said no, because I was supposed to go out there on 9/4 to meet with the complainant, Mr. Paul, and also Mr. Paxton. So short answer is I got the contract, I just didn't see it that day. It got lost in the shuffle somewhere.
All right, so tell me about how this appointment or arrangement set up for 9/4. Whose idea was that?
So I got a call from Mr. Paxton, and it was kind of like, hey, we want you to do this job. And
excuse me for interrupting. Did you consider that the notice to you that you've now been hired?
Yes, because he said I would be getting a contract, you got the job, and then he asked me, what's the hourly rate that you would charge to do this? And I said, well, I'll do it for $300 an hour. And he said, I think we can get that for you. And,
now, I'm just guessing, you correct me if I'm wrong. In your criminal practice, customarily your billing, were you charging people hourly ordinarily, or was it usually some type of flat fee arrangement?
On criminal cases, flat fee. On personal injury cases, contingency fee.
So did you have experience in charging that fee of $300 an hour, or were you just sort of guessing?
It wasn't guessing. I just was trying to consider, what was going to need to be done in the case. I mean,
Okay.
And so I landed on 300. I thought that was fair.
All right. Now, when you had that, how long did that phone call that you're describing, was that your second call with Mr. Paxton?
Yes, sir.
All right. And then how long did that call last?
I don't recall. It wasn't very long. A few minutes, maybe.
You gave him your hourly rate, and then was there an appointment made for when?
So there was an appointment made for 9/4, September 4th, 2020.
Who picked that date?
We agreed to that date because I was going to meet the complainant, or Mr. Paul, that morning. And so after, I'm in Houston, so I'm driving back and forth. I try to meet them both the same day. So
when did you receive Mr. Paul's name as the person that you were going to be, you say complainant. In other words, describe what you meant by that. when you said he was a complainant?
Well, he was the one who had made the complaint or the allegations, and so I viewed him as the complainant.
All right. Had you seen any documents as yet connected with the case?
No, sir.
And so do you recall when you first received Mr. Paul's name?
That would have been from Michael Wynn when I set the meeting up to go out there and visit with him, with Mr. Wynn for the first time, Mr. Paul for the first time.
All right. Who set up the meeting with Mr. Paul?
Mr. Wynn.
And did you inform the Attorney General that you were going to also meet Mr. Paul before you met him on the 4th?
I did.
When did you do that?
I don't recall. It was within one of those days.
Would it have been the day that you talked to him about coming up on the 4th?
Yes, sir.
Okay. So did you inform him you were going first to Mr. Paul and then coming to the Attorney General?
That's correct.
So tell us about your first meeting with Mr. Paul. How did that happen and where?
So I met Mr. Paul at his office with Michael Wynn, and I drove out here early in the morning. I met with him for, I'd say, hour and a half, 2 hours, and that was the initial time that I, had heard the allegations about their complaint.
Had you done any research on Mr. Paul, his background, who he was, et cetera, before you had this first meeting with him?
I think I may have Googled his name and read a headline or something like that.
But did you limit your looking into him to Google him? Is that about the only thing you remember doing at that stage?
Yes, I didn't look at any court records or anything. I mean, that's all that I did.
And what was your level of knowledge about him when you first went to meet him on the
That he's
4th?
A commercial real estate developer here in Austin.
Okay. Did you see that he had a search warrant executed on his house and business back in August?
No, sir.
So what was your level of knowledge of Mr. Paul at the time you met him that first time, whether you got it from the Attorney General or anyone else?
I mean, I didn't know him, didn't know anything about him.
Okay. And where did you meet him?
At his office.
Who was present during the meeting?
It was Mr. Paul and Mr. Wynn.
All right. So what happened at the meeting, without going in necessarily at this time with what he said to you, what was the nature of the bill? Who did most of the talking in the meeting?
Nate Paul did most of the talking, and it was just a lot of information given to me in a short time period.
Well, how was he doing that? I mean, how were you given information?
He was talking, and he was just talking, trying to tell me, the circumstances surrounding the search of his home.
Did he make any presentation to you?
Towards the end, he showed me a copy of a search warrant and an order, and that was kind of the gist of his complaint. He showed me this presentation on a PDF document.
And so if you had to estimate the time that you visited with Mr. Paul at that time to get his, whatever he wanted to impart to you, how much of that hour and a half or hour and 45 meeting was Mr. Paul talking to you?
I don't understand, like a percentage type thing.
Yes.
Let's just say he was talking the majority of the time. Mr. Wynn was not.
And what was your first impression of Mr. Paul? How would you describe what you saw or listened to in this meeting?
Energetic, passionate, and had a lot of conviction, kind of an aggressive attitude, just a very, energetic person.
And what was your reaction when you left? Let me ask you this. Did he basically give you his side of the matter that you had been retained to investigate?
That's correct.
And what was your reaction to it?
I mean, I was convinced by what I was shown in the search warrant presentation and all that.
So when you left, to go talk to the Attorney General, had you already formed a personal belief as to what you thought was going on here?
No, not a personal belief. I was just like, hey, if what he's showing me on how the search warrant was altered is true, this is a big deal.
Okay. And did you, at that time, say to anybody or think that it looks like they did some bad stuff?
I had not developed an opinion about one way or the other. I mean, that was my first time You know, it was kind of like drinking through a fire hose, just a ton of information coming in a short time. And when I went to Mr. Paxton's office after that, I told him it was convincing, and he agreed.
Okay. So let's move now to General Paxton, meeting with General Paxton on the 4th of September, was it?
That's correct.
How long was that meeting? Where'd you meet him?
So we arranged to meet at his office again, and the meeting was, I think, roughly 20 minutes or so.
And then what did Mr. Paxton say in that meeting?
So I told him I was convinced, it was a convincing presentation of what he agreed with that. He also said that the people in his office who were not, they weren't investigating the case, they weren't working on it. You know, at that point I had learned that there were some federal agents and people, I guess, in positions of power who were kind of involved in that. And, you know, he made a comment that you need to have some guts to work on a case like this. And I was fired up about the opportunity to do it.
Yeah. So how would you describe to the jury and the court your level now of excitement? Now that you've got a little bit idea of what Mr. Paul says, you and the Attorney General have agreed is convincing, and you think this is going to be a big deal. What was your state of mind about that?
I was excited to be working on a project with the Attorney General's office.
You were already there, right?
I mean, it's the chief law enforcement officer of our state, and, you know, it wasn't about money or anything like that. It was just an opportunity to do something new in my career and try to help out.
All right. And when he said that you as people weren't working on you, did he express anything about how he felt about that to you, or tell you whether they were not working on it or they wouldn't work on it? In your own words, what did he say?
I don't recall specifically, but he said that he couldn't get the people in his office to work on this case.
Good. And did you leave that meeting with the impression or feeling that his people were refusing to work on it?
Yes.
Did you wonder, what if they're not going to work on it, why don't you fire them?
I mean,
You didn't think about that?
No, sir.
All right. Okay. Now, after that, did that meeting get terminated a little early, or tell me? You said it was about 20 minutes.
So he said
excuse me just a second. You've driven all the way up for Houston for it. What happened to shorten it a little bit?
He had to go to a press conference, and I was going to take off, and he said, well, why don't you just come over there with me to the press conference? And so I went over there with him and with one of his staff, came over to the press conference, and then after that we went back to the office. I just kind of watched the press conference.
All right, so now not only have you been hired by the Attorney General, but you're going to a press conference with him. How'd that make you feel?
Well, I mean, I've been with my dad in press conferences before on some of his high-profile cases, but it was cool.
Yeah. Okay. All right. Now, did you think anything about? Well, let me back up. So you had 20 minutes or so to talk to him about the case. Did y'all talk about any of the facts in the meeting before the press conference?
No, I did not really have a full grasp on all of the people that were involved and all the facts of the case at that point. It was just...
Now, what was your impression or belief at that time as to the occupations or nature of the people you were supposed to investigate?
I knew that they were both local law enforcement, and some of them were federal law enforcement officers at the time.
Did you know that one of his allegations was about a federal magistrate?
Yes, sir.
What was your reaction to hear he wanted you to investigate a federal judge?
My reaction to it was just hearing out their side of the story. I didn't really have an opinion one way or the other. However, if the allegations that they were making were true, then that'd be serious.
Okay. Now, did he talk about any in that conversation, any of either Mr. Paul or him, of any people other than federal and local law enforcement being the people he wanted investigated?
No, sir.
After the press conference, how much longer were you in the company of the Attorney General?
I think probably 15 or 20 minutes. We went back to his office and finished up the conversation there.
Well, what happened in that conversation?
When we got back to the office, I was a little bit concerned because at the time, I'm in private practice, I think I had roughly 75 cases on my own docket. And I told him, I'm like, well, if I'm coming back and forth between Houston and Austin, how am I going to be able to do this? And he said, well, look, his words were, if you can just get a wet ink copy of the original search warrant, this will be over pretty quickly. And I'm sorry.
No, go ahead.
Well, just if what had been produced to Nate Paul and his lawyers matched up with the original copy, it would be over quickly. But obviously, if there were discrepancies between the original wet ink copy and his words, then this thing could drag out a little bit more.
So what did you think you were going to do originally then? And by the way, had you ever heard the phrase, and maybe it's very common, I had a wet copy. Is that what he said, a wet copy?
A wet ink copy.
What
does that mean?
The original signed one, the one the pen actually touched, the ink, because the ink is wet, you idiots.
On it.
Okay.
Not the scanned PDF version.
All right. So what did you walk out of getting back in the car to Houston? Did you think your mission was?
So we really didn't go into the scope of the work. At that point, it wasn't until I actually got so the copy of the contract had been sitting in my inbox. So when I get back home and I read my contract and see that the scope is limited to like more of an investigative role, then I'm like, okay, well, I'm a lawyer. I'm just going to collect evidence, review evidence that's presented to me.
He said he never heard it.
Draw some type of conclusion.
He said he never heard it during the question. I just like to take note. He said, I've never heard that.
And submit it. So I knew at that point, once I read my contract, that I wouldn't be trying a case or anything like that. It was limited in scope.
Can you put the original the contract up and go to the addendum A, please? I believe the contract is in evidence in several ways.
Is this in, Mr. Harden? Do you know?
Pardon me?
Is it in?
No, I already have inappropriate jokes in my mind. You have no idea how much I'm resisting. You have no idea how much I'm holding back.
Could we get an exhibit number, Rusty? Eric, can you get us an exhibit?
It is in.
It's House 160 and it's in evidence.
Thank you.
Now, do you recognize this particular excerpt from the contract?
Yes, sir.
All right. And if you could scroll up that's going to be good.
Bring a bucket and a mop for this wet ink copy.
What you realized
Give it everything you got for this wet ink copy.
I take it you're saying then you originally
There's my
imagined your
contribution.
role would be.
Just in an investigative role, and then my ultimate goal or job at the end of this would be to prepare a report of my findings and give that to the Attorney General's office, and whatever they do with it is.
And was this scope different than what you understood it to be when you originally talked to the Attorney General?
This was different than what I had, I guess, come up with in my mind, what I would be doing.
Can you tell us what lines or sentences there, Mr. Kamek, so she can highlight exactly what you noticed when you saw that it was a little bit change in the scope of what you could do?
Can I have a second or just look at this and read
So,
it?
for instance, do you see the sentence, if you would, and shall prepare a report documenting any potential criminal charges that may be discovered in the course of the investigation? Do you see that? And before.
So that's yes, sir. That's the report I was referring to.
Okay.
There's some lawyers in this house.
Restricted
There's some
role.
lawyers
Your
in this
testimony,
house.
that's really a more restricted role than you understood from the Attorney General you were originally going to have.
I'm sorry, could you repeat the
Is
question?
that a more restricted role than you originally thought you were going to have when you talked to the Attorney General?
Yes, sir.
Okay. Now, you notice it says, notwithstanding anything to the contrary contained in this outside counsel contract, outside counsel shall conduct this investigation only as consistent with the complaint referred to the OAG and is only as directed by the OAG. Correct? So who did you believe you were being hired by?
The Office of the Attorney General?
Had you had any contact with the district attorney's office?
No, sir.
Did you ever at any time during this representation think you were working for the district attorney's office?
No, sir.
Throughout your representation in this matter, whom did you think, or who hired you, and whom did you think you were working for?
The Office of the Attorney General.
All right. And in turn, throughout all of this, who in the Attorney General's office in a position of responsibility did you consistently have your contact with?
The only person I reported to was Mr. Paxton at his direction.
Okay. Now, you see, except for outside counsel's duty to provide a post-investigation report, this outside counsel contract expressly excludes legal services relating to any other post-investigation activities, including, but not limited to, indictment and prosecution. Had you yourself looked into the law that talked about the respective jurisdictions of a district attorney's office and the attorney general's office?
No, sir.
Did you ever?
No, sir.
Okay. In this particular matter, what event did you think you were going to be investigating?
The referral from Travis County DA's office.
Do you think there's a career to be made if I Weird Al
Allegedly
Yankovic,
unlawful search.
WAP,
Later, did
with
you-
legal
did
jargon?
you receive
is that a
another
thing?
referral, what's been called referral number 2?
Yes, sir.
We'll do parodies, but
Dated
only as it
September the
relates to legal
23rd.
principles and
Do you happen
cases.
to recall when you received it?
I think I got that on 9/24
Okay.
on an email from the Travis County DA's office.
And was that a totally different matter than you were originally hired to investigate?
Yes, sir.
When you got that, what was your response?
Well, I read through it, and I don't remember when I spoke with Mr. Paul and Mr. Wynn at the meeting, if it was before or after that, but when I got it, it was related to some type of alleged mortgage fraud where these lenders were wrongfully foreclosing on his properties and then trying to sell it at the auction. I don't recall any more detail than that.
All right. And when you looked at that one, of course, who was the complainant, the person who was complaining about the criminal conduct and wanted it investigated?
It was also Nate Paul.
Now, when you looked at it, did you see that it was essentially a complaint about civil litigation matters?
Are you I'm sorry, could you?
Yeah, and I'm really only asking about your mindset.
Yes, sir.
Not one way the other.
Okay.
Did you notice whether it actually was a complaint about civil litigation matters in bankruptcy?
Little Uncivil?
Well, I
Little
wasn't
Uncivil,
looking at it
the
through that
rapper?
lens at all. And to be frank
Dude,
with you,
I don't know,
didn't have
man.
any experience in handling any type of mortgage fraud or prosecuting any type of potential white-collar crime in that way.
All right. So did you just sort of put it aside and not ultimately do anything with it?
No, sir, that's not true.
Okay, well, tell me in your words.
Well, I spoke with Mr. Paxton about the referral because I wasn't sure if my scope of my contract covered that.
Certainly.
And so, you know, he said that it did. And so I was like, well, I'm going to rise to the occasion. I'm going to figure this out.
All right, so let me see if we can go through the mindset or experience for you here. You see a referral on a separate matter, which is not the one you were originally hired for, correct?
Yes, sir.
and you receive it on September 24th, and you notice it's an allegation of mortgage fraud occurred in bankruptcy court. You see that?
Yes, sir.
So how did you find out what the Attorney General felt about it? Did you call him?
Yes, sir. I mean, I'm sorry, but I don't remember the exact date.
That's okay.
But I asked
Notorious
him, I know
Uncivil.
for sure that I asked him if that was covered within the scope of my contract, and he said yes.
Do you remember what
Notorious.
the conversation was and what the rest of the conversation was?
I would just have to give you an approximation. It was roughly around the time that I received the contract on 9/24, either a day before or a day after, or the day of, somewhere in that 23 to 25th range.
I think you guys are a bad
You recall
influence on me. That's what I
occasion of
think.
that conversation with him was somewhere around the 24th of September. Did you call him explicitly for that, about whether this referral number 2 was in your contract, or were there other things that y'all talked about as well?
I don't recall the entire nature of that specific call.
Okay. Did you notice when you looked at referral 2 that one of the people that he was asking to be criminally investigated was a federal bankruptcy judge named Tony Davis?
No, sir.
You didn't notice that at that time?
No, sir.
Okay. Did that referral, just like the first referral, have a list of people that Mr. Paul claimed were people of interest?
It did, yes, sir.
All right. And did it list these people? Do you recall whether when it listed them, whether it listed actually personal data like their address and their phone numbers?
I don't recall if that was in the referral or not.
All right. Don't remember whether it was in referral number 2. Is that what you're saying?
Yes, sir.
All right. Was that the case in referral number 1?
Yes, sir.
Okay.
There were names and I believe some demographic information.
All right.
The first one. I don't recall.
Now, in referral number, I mean, let's go back now to the period a little before September 24th, when we were talking about the original referral. After you returned, did you receive any type of documents and materials to review when you left the meeting with both Mr. Paul and back on the 4th of September?
Yes, sir.
Can you tell us what kind of materials he gave you that you took back to Houston to review?
So I had taken my handwritten notes from the meeting back with me. And then I also received like a little 5 or 6 page document that appeared to be some type of timeline of events giving Mr. Nate Paul's version about what happened.
All right. Now, did you take that just as his version?
Yes, sir.
All right. But when you left there, what did you have when you left there and then on the 4th and after your meeting with the Attorney General? Had you developed sort of a game plan in your own mind as to how you were going to do the investigation?
So I did. I was trying to consider, how to get information to either corroborate or contradict what was being said.
All right. And did you tell us how you viewed the role of Mr. Paul and his lawyer, Mr. Wynn, in this, in terms of what role were they to play in the upcoming investigation?
Well, I viewed Mr. Paul as the complainant. He's the one who was complaining of these allegations, and then, Mr. Wynn was his attorney in some other separate matter.
How did you view your role as the Attorney General? Did you look at them almost as a client in terms of them sharing information with you and all? How would you describe that in your own words? With who? Mr. Paul.
Okay.
And of course, Mr. Wynn's his lawyer. But in your view of did you consider yourself as like a prosecutor and a citizen had come in and made a complaint?
I viewed him as a complainant in the case, and just in the same way that if a client hires me for a case and they bring in a banker's box full of documents and information, I'm going to go through it. And so I didn't think that it was unusual that I would be getting information from the complainant and his attorney. And as I got that information, I thought this was the same information that Mr. Penley had.
Yes. Had you met Mr. Penley?
No, sir.
Did you ever meet him?
No, sir.
All right, so when you originally were hired by the Attorney General, did you make a certain assumption as to what your role in Mr. Penley's would be?
Well, I thought I would meet Mr. Penley at some point. I remember I asked Mr. Paxton in that first or that second meeting if I'd be meeting, am I going to talk to him? Does he have a file that I can start working with? And his response was, I think he was out of town, and he had a file on his desk. So I did assume at some point that I would meet Mr. Penley and take a look at his file.
Well, did you assume originally that you would be working with the Attorney General's staff as you gathered information, and that would mean that you'd be working with the division head?
I did. I mean, obviously, as a solo practitioner, I don't have access to a lot of the resources that government offices has. And so I thought at some point I would be dealing with or meeting with some of these individuals.
Right. And so did you just assume that Mr. Penley was being kept informed as what was going on here?
I didn't really think about that at the time.
Okay, fair enough. But at any time, how many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
I'm sorry, I didn't understand the question. Can you repeat your question, Rusty? I didn't hear it. I'm sorry.
Sure. How many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
Thank you.
I asked, it's kind of two parts. So with respect to Mr. Penley, I'd only talked to him about Mr. Penley maybe twice, and then that was early on, and then that's when I was asking about, was there a file, how do I get in touch with him on this deal? And then as far as getting support from the office, I think I asked probably 4 or 5 times over the course of this 3.5 week period when this all happened, can I get badge, can I get credentials, which I never got, but I repeatedly asked for those things.
And what was the Attorney General's response each time?
I think initially his response is, okay, we have to get somebody to work on that, or we'll get it to you. It's just I never got a firm answer on when I would be getting those things. I knew I would need it when it came to issuing subpoenas and things like that.
Yeah, so what things were you asking him for? Let's start with Mr. Penley. Each time that you asked him or mentioned Mr. Penley, did he have some reason not to put you in touch with Mr. Penley?
The only thing that I asked about Mr. Penley was, did he have a file and will I be meeting with him? To which his response was, he's out of town and his file is on the desk. I just thought in my mind that I would eventually meet with him to discuss this case. I mean, I don't know anything about any of these people in that office, and so I'm like, I didn't know anything going on. So
how did you know Mr. Penley? Just looking at a flow chart? How'd you know about him?
I knew the name from Mr. Wynn and Mr. Paul in that first meeting.
Did Mr. Wynn and Mr. Paul, were they critical of Mr. Penley in that first meeting?
Yes.
What'd they say?
Well, they said that Mr. Penley said that there was no information that could be presented to him that would make him believe that a federal official broke the law in the way that they claimed.
All right. And this conversation with them was that was the one September 4th?
Yes, sir.
Okay. Now, do you think that's a little strange that they didn't want to deal with the head of the division in the Attorney General's office?
My understanding was that they had met with him one time.
That's all, just one time?
Yes, sir. That's what I was told.
Is that what they told you?
Yes, sir. And he refused to look into it. And then that was kind of reinforced by the fact that Mr. Paxton said that he couldn't get anyone in his office to work on the case.
All right. So in your conversations with them and as your investigation, were you ever told or informed that they actually met with Mr. Paul 3 times?
Excuse me, Your Honor, that objection hearsay, that includes other people other than Mr. Paxton.
Sustained.
Let me ask you this. Did you ever learn from Mr. Paul, Mr. Wynn, or Attorney General Paxton that Mr. Penley...
Excuse me, same exact
Let
objection.
me just finish, please.
I'm sorry.
That Mr. Penley or Mr. David Maxwell met with Mr. Paul and Mr. Wynn 3 times.
Okay, that's both multifarious and hearsay.
Sustained.
Did you ever learn that Mr. Penley, did you learn anything from any source about how often Mr. Penley was trying to get Mr. Wynn to provide further documents?
Objection.
Objection is only was he aware of anything like that?
Objection, hearsay. The question was, did you learn from any source? Objection, hearsay.
I'm only...
Overruled.
Thank you. Were you?
I'm sorry, could you please repeat the question?
Sure. Were you ever aware from any source that Mr. Penley, after 3 meetings, was continuing to try to get documents from Mr. Wynn? Did you ever hear that from anybody?
Objection. I'm sorry. Objection, hearsay. I apologize. Sorry, Mr. Kamick. Sorry, Rusty. Objection, hearsay.
Sustained.
In your mind, what was your understanding from any source of the level of involvement of Mr. Penley and Mr. Maxwell in this investigation?
I'm sorry, Rusty, the level of?
I'm not asking for any statements or anything. I'm asking what his understanding of mindset was.
I understand. I just didn't. You said the level of, and then the word trailed off. I'm sorry if I'm being difficult.
How sorry are you?
Pretty sorry. Sorry enough.
All right. My question, I think, stands, Your Honor. I simply want to know what his state of mind and level of knowledge was, because it has a lot to do with what he does later.
Yeah, I didn't hear an objection, actually. I just heard him say...
I didn't either, so...
He just said he couldn't hear you. So.
I just didn't understand the question. That question, as asked, I'm fine. Go ahead.
Is your microphone on?
Well, he's reading it. I can't read that far. Go ahead. I'm sorry.
Thank you. Now, in at the end of the day, what was your level of knowledge about this?
So I was told early on by Mr. Paxton that the people in his office weren't doing what he asked them to do. That's why he was considering hiring outside counsel.
Right.
And then towards the end of September, in this 3.5-week period, I was told by Michael Wynn that Mr. Penley had reached out to him kind of out of the clear blue for documents. And then I asked Mr. Paxton about that when I spoke with him, and he said, well, I told him to stand down. He's not working on this case. You are.
And who should stand down?
Mr. Penley.
Yeah. General Paxton told you that Mr. Penley should stand down. He wasn't involved in the case anymore?
That's correct. And that was my only other time that I knew about any of his involvement.
All right. Do you recall when that conversation was and where you were?
It would have been a phone call towards the end of September.
All right. Thank you. Now, let's go back after the 4th. I assume you started reviewing the materials you had received?
Yes, sir.
Tell us about how you proceeded in your investigation then.
All right, so still trying to get my arms around what was alleged and all of the folks that were involved in it, and trying to figure out, since I didn't really have any information, what information I would be able to obtain. And just started kind of thinking of the way to do this would be to do grand jury subpoenas to get information regarding like phone calls and things between the individuals involved in that first referral.
All right. Now, by the way, did you during this period of time, Mr. Kamick, consult with any other people you thought might have had these types of investigations before to sort of get an idea how to proceed?
No, sir. No,
this
sir.
is not something you had done before, correct?
I had not ever done this before.
Okay. Now, by the way, in your communications with the Attorney General, how were you communicating with him? by phone, by text, by email? Can you describe the forms of communication y'all used?
So we spoke by phone and through text message, and then throughout this process, I continually forwarded emails to him as something would come up or I would get some information.
Well, did you use any kind of encrypted communications?
Yeah, I think about the middle of the month, he asked me to use the Signal app, which I wasn't really familiar with at the time. I just thought it was like a WhatsApp or just a messaging
You weren't
deal.
familiar with Signal app at that time?
I'd never used it before.
All right. And how did that come about that he wanted you to communicate with him using Signal app?
He asked me on a phone call to download the app and use that.
Did you go on the internet to look and see what a Signal app was?
No, sir, I just downloaded the app.
Okay. And do you recall what the nature of the conversation was in which he asked you to start using Signal app?
It would have been a call where we were talking just generally about the case, kind of the status of it and what was going on. It wasn't I do remember it was not a phone call specifically about using that app.
And what type of email address did you use with him?
But what do you mean?
Well, do you recall what the email address was?
No, sir.
Was it an official Attorney General's office email address?
Oh, I see what you mean. No, sir.
All right. What was it?
His email address was a Proton mail address.
All right.
That I was given.
Had you used Proton before?
No, sir.
Had you ever heard of Proton?
I had heard of it. I've never used it.
Okay. Now, in addition, what about the phones? What type of phone number did you have that you would communicate with him?
I had the original number that he had first called me on, and then I think later he gave me another number. Around that time, I was getting calls from unknown numbers, or it'd say potential spam. You know, you get those types of calls, and I was like, well, I don't want to miss the Attorney General's number, so I got myself a separate number and gave it to him. That way I knew when that phone rang, that was Mr. Paxton calling.
So are you saying that you ultimately got a phone that was totally dedicated to phone conversations with the Attorney General of the state of Texas, and that's the only number that you communicated with on that phone?
Yes, sir.
And you did that why?
Because I didn't want to miss a call from an unknown number or a spam likely call, or, you know, when you get those spam calls, I didn't want to have that come up and miss an important call. So
did he use multiple phone numbers with you?
Yes, sir.
How many?
2 numbers.
Okay. And were either of those official Attorney General lines?
I believe they were cell phone numbers. I don't believe they were office numbers.
All right. In fact, when was the first time that you ever learned what the official email address or the Attorney General office email address was of the Attorney General that you were dealing with all this time?
The first time that I ever saw his governmental email address,
yes,
was when I got a cease and desist letter from Jeff Mateer.
And when was that?
That would have been, I believe, August 1st or 2nd.
And how was it that you saw what the Attorney General's official email address was?
They were all copied on the email. All the gentlemen, Mr. Vassar, I think, was one of them. And
was that first time when you got your cease and desist letter, the first time you ever knew of any official communication form of communicating with the Attorney General, whether it was through text or email or phone?
I thought all of my communications with him were official, but that was the first time that I saw his governmental email address.
All right.
Yes, sir.
Now, did you trust the Attorney General?
Yes, sir.
Were you flattered about him reaching out to you?
Yes, sir.
Did you trust Michael Wynn?
Yes, sir.
Did you appreciate him referring you to the Attorney General?
I did. Yes, sir.
Okay. And did you always trust Michael Wynn to have your best interest at heart and try to help you?
Yes, sir. I didn't have any reason not to trust him. I knew that he was Nate Paul's lawyer.
Okay. Did you trust Nate Paul?
Didn't really know Nate Paul. Just was trying to do my job.
All right, now let's move to the period of the middle of September. After you came back, you had all your material from the 4th that you'd gotten from Nate Paul. What did you do after that?
So around this time, I had a conversation with Mr. Paxton because I wanted to try to get the individuals named in that first referral, like call logs and email logs showing whether or not these people had been talking around the time that the search had taken place. And so, being that it's sensitive, since they are federal agents and there's some people in power there, I thought that the grand jury subpoena would be a discreet way to get that information. And so I brought that up to Mr. Paxton.
And do you recall when this conversation was?
I believe it was around, we had talked about it from early on in the month, like within that first week of September, but the conversations kind of continued going on until about the middle of the month, about September 14th.
Okay. Now, at that time, what did you say to Mr. Paxton, and what did he say to you?
I told him I think we should try to do a grand jury subpoenas, being that this is a discreet way to get information. Grand jury proceedings are private and secret proceedings, and so we'd be able to get information that way without raising any kind of alarms or causing some type of, panic about the situation. And he said it was a smart idea.
So he endorsed it?
Yes, sir.
Did either of you talk about the fact that if you issued grand jury subpoenas for a claimed offense that Mr. Paul was presenting to you, that the recipients of those grand jury subpoenas would know what was going on, or have questions, or be maybe even alarmed? Did y'all discuss that at all?
Excuse me, objection leading.
I think I gave him several choices.
Sustained.
Did y'all talk about the possible reaction of people that got these subpoenas?
There you go. That's better.
No, sir.
Later you issued subpoenas, did you not, for credit unions and banks and stuff like that, correct?
Yes, sir.
Was there any conversation between you and the Attorney General about how those people might feel when they got those grand juries?
No, sir.
Did you become later aware, we'll get to who all that were on there, of that some of these subpoenas were going to lawyers or people that were opposing Mr. Paul in litigation? Were you aware that that's who some of the people were?
No, sir.
Okay, well then let's get to what you know. When you talked to the Attorney General back about downloading the app and everything, were you also talking to him at that time about trying to seek credentials and other types of things that you needed for what you were doing?
Yes, sir.
When did you first start asking for those types of things?
In my first meeting with him on September 4th, and then I asked about it again, like as I'm approaching the time where I need to be, as the time I'm doing the applications for these subpoenas.
What did you ask him for?
Email address, am I gonna get some type of badge or some credentials, like, because I'm going to be approaching people with legal documents and I need something to show that I have the authority to do that.
What did he say?
We're working on it.
Now, you assumed, did you not, that of course it'd be perfectly fine to give you those things because it would be a public record and there was nothing wrong with it, correct?
I expected to get that.
Yes. And you expected and believed you were going to need that, did you not, in your investigation?
Yes, and I ended up, I did need it.
How many times do you think you asked the Attorney General for these official documents?
It would have had him in 4 or 5 times over the course of a month.
And each time you asked him for him, what was his response?
We're working on it. We'll get it to you.
At some time, did you begin to wonder why they would not give you any kind of official documents to show your status?
No. I don't know how the office operates within the Attorney General's office. I wasn't sure if there was a bunch of red tape to go through. I didn't know any of that. I just knew that I would need it to do what he was asking me to do.
Right. We always hear about the slowness of bureaucracy and government agencies. Is that the kind of thing you just thought was going on?
Yes, sir.
Okay. So it never occurred to you that maybe he didn't want them to be public?
objection, leading and assuming facts not in evidence.
Sustained.
Did it ever occur to you? Did you ever have the thought, a wonder, don't they want this public or what? Did you have that kind of thought process?
I wasn't thinking about anything like that.
Fair enough. Now, when you mentioned
asked the leading
jury
question for this damning answer, and the guy's
Attorney
like,
General,
no, that
in
wasn't my thought process.
conversation,
It's like,
And you think that conversation was when,
you
roughly?
do all this work to get the biting
been
admission, and it's like,
around-
no, that wasn't what I was thinking. Okay, that's great.
I know I spoke with him about it on September 6th. So I have a note here on this invoice, but the middle of the month around September 14th.
Okay.
There were a couple conversations where I was just kind of trying to figure my way through this.
Now, you, of course,
I
as
like
you
this
mentioned
guy.
before, had never done a
I
grand
like the
jury
witness.
investigation, correct?
That is correct.
He comes off as very
So,
credible to me.
Did you ask him some
Particularly
questions?
because,
Attorney
like, he's not
General,
just
some
automatically
questions to try
agreeing
to
with the
help you in that
lawyer.
respect.
And like the
First
lawyer
of all,
is obviously
did you
trying to feed him
assume
answers, and he's
maybe
like,
he
nah,
would
that
give
isn't
these that
quite
kind of
right.
answers?
So it's like, I like the guy.
Sorry. Judge, is there any way I can use a restroom break?
We'll stand at ease for 10 minutes?
Sorry about that.
No. We'll give you 10 minutes. The witness may step down.
Thank you, Judge.
Okay.
Thank you very much.
I would just stand at your desk, George. I would not leave. He's just stepping out and coming right back.
He needs to use the restroom. Lol. I like this witness. He comes off as very authentic. And I do appreciate that, the guy's trying to feed him answers, and he's still like, no, that's not quite right. That's not exactly what happened. It's not exactly what I felt. It's not exactly my recollection. So even though the lawyer is leading him, he's resisting the lead and giving it his honest answer. And I appreciate that. It's like he comes off as very authentic. So I don't know if that's by design. If it's by design, it's genius. Right? That Rusty is asking these deliberately leading questions just so the witness will correct him. If it's all part of some master plan, it's genius. But either way, I appreciate the guy. And it's like, he just seems as very authentic, telling the truth. This is his perception of things. He thought the Attorney General empowered him to be a special prosecutor. He didn't know what that meant necessarily, because why would he? Fair enough. He doesn't know what that means. He doesn't know what it necessarily means within the office. He just assumes the AG is appointing him to a role because the AG says he is. And he's like, okay, I take it at face value. Why not? And it's like, I need to be able to have these credentials to do these things. You want me to do the things. I was doing the investigation. I was trying to further what I thought the Attorney General wanted me to do. I was getting resistance to trying to do what I thought the Attorney General wanted me to do, and so forth and so on. So, fair enough. So far, so good. Yeah. So this is good. Thank you, $10 from Austin, Pro Courier and Apostle. So this is leading us a lot more to, what was it? Charge 5 from the list of charges. This is all, let's see. Engagement of COMAC. So this is Article 5. We're getting some testimony on Article 5. While holding office as Attorney General, Kenneth Paxton misused his office by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brian Kamek, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nepal. So we're getting evidence that is supporting Article 5. So we're definitely teeing up like it's the Attorney General who's appointing this guy to do these things. It's Kamek who's the one who's issuing the subpoenas, as far as Kamek is concerned. So we're getting some information that's supporting 5. So I appreciate that. I don't know whether he's naive or not. I don't know if that's naive. Why wouldn't you just trust the Attorney General when he's just telling you things? Like the Attorney General would presume. I mean, he is the highest law enforcement officer in the nation. I don't think that's necessarily naive. Yeah, that doesn't seem naive to me. But maybe you guys have a different view of naive. Yeah, he seems young and hungry. He wanted to do a good job. He wanted to do what he thought the AG wanted him to do. He was trying his best to further what he thought he was being hired to do, and he's basing that off conversations with the AG, and he's saying, yeah, AG was the one who used the term special prosecutor. AG was the one who wanted me to do that. AG thought it was a good idea to issue the grand jury subpoenas, and so forth and so on. So it's like, okay, we're getting some evidence that helps support that proposition. Yeah, maybe. Yeah, Kamek thought he was doing what he thought was right. Maybe didn't realize that he was being used. But then again, that would be on the AG if he's being used. If the AG is using him as an unwitting pawn, then that's very much on the AG now, isn't it? Right? So, maybe he was being used as an unwitting pawn, but well, blame the Kingmaster at that point. Yeah.
Court will come to order, and hold on one moment, Mr. Hardin, for all the jurors to be seated again.
Mr. Kamek.
Hold on 1 second. They're not all in their seats.
You're right.
Looks like we're short 2 members. Mr. Hughes and Mr. Miles. Senator Miles, Senator Hughes, please come forward.
I mean, it sounds to me like he is doing the same things I would do. I very much see myself in this guy, in his relation to the story. It's like, I'd feel pretty honored if the AG's office gave me a call. I'd want to do the best job possible for the AG. You don't want to disappoint him. You want to do your best. So I see some of myself in him.
We're 1 juror short, so we're going to wait. We're texting him now.
And then feeling frustrated that you're not able to do the job that you were hired to do, in your view. You're being asked to do things and don't have the ability to do what you want to do. That would be very frustrating.
Mr. Hardin, you may resume.
Thank you, Your Honor. All right, Mr. Kamek, I want to go to, if I may, when you were asking him and talking to him about the grand jury subpoenas. During that conversation, and you mentioned that you asked him about credentials. How did you go about trying to find out how to do a grand jury issuing and using grand jury subpoenas? What did you do? Your microphone.
Yes, sir. So I asked Mr. Paxton, it's, at this point, he's like, this is a smart idea. This is the way that we should proceed. So the next question is, okay, well, how do we do this? Because I wasn't sure whether the Attorney General's office had their own special grand jury in session for cases, or if we would do it through county, like Travis County grand jury. And so I didn't know the answer to that. He said he didn't know the answer to that. He would need to find out. And, I think he had indicated to me at that time, he wasn't a criminal lawyer. Most of his experience was in business law. So he would find out which grand jury that we would.
And did you find out?
He reached back out to me around the middle of the month, maybe a day or so after, and told me that we would be going through the Travis County grand jury.
But the AG himself called you back and told you that?
Yes, sir.
And then what did you do?
So my next step was to reach out to Travis County District Attorney's Office, and it was kind of weird because before I even have an opportunity to do that, I get a message or a voicemail that Michael Wynn had sent me saying, this is the person that you need to contact over there.
How soon after you had the conversation with the Attorney General that concerning the fact that it would be a Travis County grand jury, how soon after that conversation with the Attorney General did Mr. Wynn reach out and give you a contact in the Travis County DA's office?
I don't recall exactly, probably within 24 to 48 hours.
It's pretty weird.
Do you have any idea how Mr. Wynn would have known that you were seeking that information?
I'm sorry.
Had you told Mr. Wynn you were trying to find out, or did it just come in unsolicited?
No, I spoke with Mr. Wynn about the grand jury process.
All right.
So he was aware, him and Nate Paul were both aware that that's how I was proceeding with their investigation.
When you got that information, did you reach out to the Travis County grand jury?
I reached out to the Travis County District Attorney's Office and spoke.
Excuse me, I said grand jury, you're right. The office, excuse me, go ahead.
I spoke with, I forget, it was a nice woman, I forget her name. She put me in touch with a gentleman named Don Clemmer. And then Don Clemmer put me in touch with, I guess, this real sweet lady. I think her name was Bailey. She might have been the grand jury coordinator over there.
Let me ask you this. Was it last name Mulder? Does that sound?
That sounds like
all right.
Correct.
Did you tell these folks that you were a special prosecutor working with the Attorney General's office?
Yes, sir.
Okay. And as such, you were asking assistance to get some grand jury subpoenas?
Yes, sir.
And did they help you get the grand jury subpoenas?
Yes, sir, they did.
And let me ask you, at this time, Your Honor, I want to move to introduce en masse, I believe we informed counsel on the other side, Exhibit 257, which I'll represent as all of Mr. Kamak's production in this matter to both sides. These are the documents that he has produced to lawyers on both sides, and I move to introduce them in toto.
Any objection? Speak on the microphone, please. Still can't hear you.
Yes.
Object to 649, 691.
Dan, can I stop you for just a second to explain to the court? We have given them excerpts. So that it was too voluminous to be carrying around the hard document here. But what we did do, about 2,000 pages, I think it was a lot. What we've then I've gone through and taken out excerpts and put an exhibit number on them. But they are excerpts from what I was seeking to do was introducing the whole group and then taking out and putting an exhibit number on those that we specifically were going to talk about.
I'm so confused. What are you trying to do now?
I appreciate all that, Mr. President, but to be clear, we got an amended exhibit at 4:50 this morning, which includes these, several of which I will be objecting to, several of which I won't.
Excuse me, are we going to start getting into when we get stuff for them and what time of the morning? I would just ask for
just stop right now.
Yeah.
You would, like I started to say, object to 649, 691, 687, 688, 689, 690, 686, and 650.
Reason for the objection?
Sir?
You objected to those documents, okay?
I am. Now,
Okay.
I do not have objections to 677, 678, 679, 680, 681, 682, 683, 684, 685.
Bingo.
And 693. The last sequence, Mr. President, I do not have an objection to.
So let's go back to the objection.
Yes, sir.
I'd asked you for a reason for the objection to the
Yes, sir.
other documents?
Yes, sir. The basis is hearsay on each. And just so, let me try to get them in order so Mr. Hardin and I can literally be on the same page.
May I ask one more time real quickly the ones you object to, Dan?
Sure.
To make sure I got all of them.
Yes, sir. The ones I'm objecting to are in order, Rusty, are 649. That's the work product. If you're with me, you want me to come over there? I'm happy to do that, if that's easier for you.
No, go ahead.
649, 650, 686, 687, 689, 690, and 691.
And the type of objection, Your Honor, the basis.
Hearsay.
Hearsay.
He said.
And I don't know if you, Judge, Mr. President, do you have them in front of you?
We're going to be here a hot
I do
minute, I
this,
can tell.
do this. Let me go right now to discuss the ones that that has no objection to and ask that they be admitted.
Sure.
Okay, we'll admit the items that you have no objection to, and to be certain we have those right numbers, would you repeat those numbers that you do not object to?
The numbers that and I'm not sure these are in order, but 677, no
Yes.
objection.
Okay,
678, no
Yes.
objection. 680, 681, 682,
yes,
683,
yes,
684,
yes,
685,
yes.
and 693.
What about 679?
All right.
Hold on one second, just checking this.
You inquired on
but
679. I don't have that one in front of me.
Okay, you originally said you had no objection to 679, but you may have misspoken.
Certainly capable of doing that. No, you're correct, Mr. President. 679, we do object to 679.
Okay, so 679. So to the court reporter, and forgive my for a moment there, something I said the witnesses shouldn't do. So to be clear to the court reporter, no objection to 677, 678, 680, 681, 682, 683, 684, 685, 693. And it's my understanding, Mr. Hardin, to begin, you will just focus on those. And if you want to refer to the others, you'll have to give us an answer on why it's not hearsay at that time.
That's correct. Your time, could I?
I'm admitting, so we are admitting into evidence 677, 678, 679, 680. I'm sorry, 677, 678, not 679 at this time. 680, 681, 682, 683, 684, 685, and 693.
Your Honor, can I have 10 minutes credit back because of the housekeeping we did here?
Did you say you needed 10 minutes?
Could I have 10 minutes credit back for the conversation we've had?
I'll give you 5.
Thank.
All right.
All right. One has to take what they can get. All right. Mr. Kamek,
Yes, sir.
did you start receiving assistance to get these grand jury subpoenas done as to who they would be from Mr. Wynn?
Yes, sir.
And is it still on? I didn't hear. Yeah.
Can you hear me?
Yes.
Okay.
Yeah. All right. And what form of assistance were you getting from him?
Well, I started to get a lot of information from Mr. Paul and Mr. Wynn through emails. That included the list of individuals who were, I guess, suspects or somehow witnesses or somehow related to that first initial referral.
And were these people that were to be put on the list of subpoenas?
Some of them were, yes, sir.
All right. And were you receiving from Mr. Wynn regularly information of people to include on the grand jury subpoenas?
Yes, sir.
Now, what was your thought process in terms of your investigation as to why you would automatically put those people on if they're asking? In your mind, you were doing what?
Well, I didn't independently source any of these individuals' name. I walk into this referral, and I'm given a lot of information about different people who were involved and how they may be related to that first referral. And so I trusted that that was the information that that they were giving me was the same information that the Attorney General's office, Mr. Penley, would have already had to conduct his investigation.
All right, so you assumed that you were just getting information that already existed?
Yes, sir.
In the hands of the AG?
Yes, sir.
But you hadn't talked to anyone in the AG, correct?
Other than Mr. Paxton, that's correct.
All right. And each time that you had a course of action in this case and thought you were going to do something, did you have a practice of contacting the Attorney General to update him?
Yes, sir.
And so as you went along and gathered all this information from Mr. Wynn and Mr. Paul, were you keeping the Attorney General informed of all this?
Yes, sir. I would discuss it on the phone, or anytime I got like a document emailed to me from Mr. Wynn, I would forward that on to the Attorney General's email address. And then when we spoke again, if we did, I would say, hey, you know, I sent you this or sent you that.
So let me see if I understand. Whenever you received information from Mr. Wynn and or Mr. Paul by email, you would then forward that information to the Attorney General?
Limp Bizkit is the greatest band ever.
The majority of the time, yes, sir.
Well,
so when they were
it is all about the he said, she said bullshit. I mean, that's true.
That should be subpoenaed by the grand jury. Were you making sure you kept Mr. Paxton informed of that?
I'm sorry, do you mean if, like, I sent that information to him, or just letting him know that I received that information, or?
Just letting him know that you received that information.
Yes, sir.
All right. So would it be an accurate statement that as you proceeded in this, well, let me put it another way. As you proceeded in your investigation, and as you determined what to do with the grand jury, and what to do about grand jury subpoenas.
I've got jokes, people.
At each stage,
I've got jokes.
The Attorney General informed.
Yes, sir.
At any time, did the Attorney General contact you and said, no, don't do that?
No, sir.
So from your own state of mind, in every single thing you did in this investigation, what is your testimony to the jury as to whether you believed you had the full support and agreement of the Attorney General of the state of Texas?
That's true. I did everything at his supervision, kept him informed on everything. When I reached out to Travis County District Attorney's Office and introduced myself regarding the grand jury subpoenas, I mean, I got affirmation the entire time that everything was good, and no one said anything different until I, got a cease and desist letter at the end of.
And so it was one of your frustrations that you didn't have anything official to tell people that's what you were doing. Is that correct?
That's right.
Excuse me. Objection leading.
I'm sorry.
Well,
Sustained.
were you frustrated about not having any identification and documents and means to tell others in the outside world?
Yes, because, yes, sir.
All right. And what was the reason? What was the reason for being so frustrated?
For example, when I had some subpoenas issued for Microsoft, and I got an email back saying, without a governmental email address, we can't execute these subpoenas. So I knew that as I'm continuing to work in the course of this deal, that I would need to have some type of identification, whether it's a governmental email address, some number. I don't know what their processes are, but I knew that I would need some type of credential to be able to do what I was asked to do.
What were you subpoenaing Microsoft for?
Email records, I believe, for certain individuals that were involved in that first referral.
All right. So in the first referral, you were seeking email information, everything from Microsoft about all of these individuals?
Whoever had like an Outlook email address.
And in addition to the people involved in the execution of the search warrant, were you receiving from Mr. Wynn other names that should be added in?
I don't recall all of the names that were on the list.
Oh yeah, I'm not asking you what the names were, but were you receiving during this time that you were conducting an investigation, continued list and suggestions of people to investigate and to list a grand jury subpoena for?
Yes, sir.
And at this stage, did you reach a stage of discomfort that you were getting all this information from the lawyer of a man that you knew was already under investigation by law enforcement?
Objection leading. No?
I didn't know that Mr. Paul was under investigation at the time. I knew about the search, obviously, but I didn't know that he was under any kind of, at the time, it would have been a current investigation. And then just with respect to Michael Wynn, I had no reason not to trust that Michael was giving me information that he had already collected.
Maybe we gave up on objection leading.
So
I mean, we gave up on objection compound. No one has
he
made a
gave me
compound objection this entire
for the
time.
purposes of investigating that referral.
Okay, I want you to look. I'll put some hard copies up there for you. It's in
Yes, sir.
evidence now. Exhibit 678.
678.
And it's going to be bait stamp. Or do you need a bait stamp? No. Okay, thank you. Can you tell us what that is, please?
So this is an email that I sent to Ryan Vassar with this is the same day that I met with Mr. Paxton on 9/4, and when I got back home, I signed the draft contract that they sent me and sent it back, and I asked for an executed copy back. Mr. Vassar had asked me to see if there were any kind of conflicts, so I reached out. I didn't have any clients that had any cases pending where the AG's office was opposing counsel, and I reached out to the State Bar Ethics Hotline and said, hey, is this okay? You know, I don't have any cases pending against them, and they said, it's fine, you know, congratulations on the job.
Cute.
All right. I'm trying to look at these subpoenas in terms of what's admitted, and I want you, if you would, to turn to 681. I'm only going to ask you to not put it up because I believe that's one no, that is one that's in evidence. Can you help me out? Look at 681 and identify this for the jury, please.
So this was an email from me to Michael Wynn, and it says sample form grand jury, Google grand jury subpoena.
All right. And then look over to why did you send it to Michael Wynn?
Michael Wynn had initially, so I had never issued a grand jury subpoena before.
Pardon me?
I had never issued a grand jury subpoena before.
Right.
And so I asked Michael, once I put this draft together, if you take a look at it, it's the same information that they had already given me, and make sure that the form here is correct.
And so Mr. Wynn respond to you and tell you it was okay?
He said, form is fine.
And then, what? At the end of the day, what did that help you
The fact that
do?
Mr. Wynn is involved in this as he is
help me
making
do?
me very
Yes.
uncomfortable as a lawyer.
Did that help you decide how you were going to do the subpoenas and what language you were going to use and everything?
Mr. Paul's personal lawyer is like
sent this to
directly
him. I mean, I
involved
knew he was a federal
apparently
prosecutor
on
at
how
this
to do
point in
these
the past.
things,
You know, Harvard educated. I just
who
sent it
to
to him
contact at the office.
Does the form look okay here? So it helped me to know that this was the right way to do it.
All right. Your Honor, I'm looking here. I was having to order up the ones they've objected to. And there are some of these that I very much want to get into evidence. and I don't believe there is a legitimate objection.
Mr. Wynn should
Trying to
not be
figure out
this
how to
involved
handle
in this.
Without taking any undue
Mr. Wynn
time
really
now.
shouldn't be involved at all.
For instance, if I could,
No.
do we have hard copies for the court, Stella?
Beyond being present when
Of these
Mr.
exhibits,
Paul
do
is
we have more
talking, but he
staff?
shouldn't be interfacing with the AG's office like this. Because suddenly we're taking direction from Mr.
You had
Wynn, which
before
is to
you
say we're taking
691
direction from
without
Mr. Paul.
referring- Without saying
And
anything
that's
about
not
what
good.
the content is. I want you to identify it for the record and tell us what it is.
Mr. Hardin, you said 691?
Yes. I wrote that down as one you objected to.
I don't have a 6. Oh, I do too. I stand corrected. Thank you.
We have that on the list you objected to, correct?
Yes, sir. I'm sorry.
Well, we're waiting for us to see it. We don't have a copy before we can rule.
Yes, sir.
All right. You see 691, would you, without talking about the internal contents yet, would you describe what that document is?
This was an email from Michael Wynn on September 21st, 2020, with an attached Excel spreadsheet that appears to have individuals' names listed there with various demographic information.
Does it list names, addresses?
Yeah, Wynn
and
went with
identifying
him in
data
person to serve the
that
subpoena,
have
yeah.
been
So there's all
blacked out
kinds of
for
problems
purposes
here.
of this exhibit, but does it list names, addresses, and personal data of people to be investigated and included on the grand jury subpoena?
Yes, sir.
All right. I don't understand what the objection was to that, Your Honor.
The
Well, give
objection-
us, go ahead, I'm sorry.
The objection is hearsay. It's not a list created by Mr. Kamek, but by Mr. Wynn, and it is being offered for the truth of the matter asserted because they're going to...
Your Honor, go ahead. I'm excused if you were talking. No, I thought you were through. Go ahead.
That's okay. It is going to be offered for the truth of the matter asserted because they're going to be arguing that these were the names ultimately where subpoenas were being used on. So objection, hearsay.
There are a series of these, Your Honor, that first of all, not offered for the truth of the matter, only that was provided to them. We are not suggesting that these people should be and were witnesses for the grand jury, should have been a grand jury subpoena. But more important part is, Article 16 is a conspiracy article that says that General Paxton engaged in conspiracy with others. We are not alleging that they engaged in this conspiracy with Mr. Kamek. We are alleging that he engaged in a conspiracy with Mr. Paul and Mr. Wynn. And any statements that are made in pursuant of that conspiracy would be admissible, whether or not it is hearsay. It's an exception to the hearsay rule. I know I am springing that on the court. You might want a moment to think about it or so, but that's why, A, it's not hearsay, but B, even if
Statement by a co-conspirator?
it is an act in furtherance of the conspiracy.
They are admissible through the testimony of a co-conspirator, not through Mr. Kamek, who Mr. Hardin admits is not a co-conspirator.
Give us a moment.
Pardon me? Okay.
I don't think his conclusion is correct. If he's a co-conspirator, I think it's admissible. Because it's a statement against interest.
Just, Judge, Mr. President, while you're considering this, I would, based upon Mr. Hardin's argument for the admissibility of it, there is no suggestion that General Paxton created or participated in the creation or the assimilation of this exhibit.
Okay, give us a moment.
Good question. Interesting question. It'll be interesting to see which way they come down on it. Yeah, because it's a statement against interest, right? So if it's from Mr. Paxton, then it's admissible because it's a statement against interest. It's from a co-conspirator. So it's a statement against interest for the conspiracy. Mr. Paxton would be bound by the statements of his co-conspirators.
Your Honor, if I may, there's a business records affidavit, Exhibit 547, a business record affidavit for all of Mr. Kamek's files. So the idea of this hearsay goes out the window. It would have to be kept. It would have to be kept out for some other reason.
Business
These
records.
all have been certified. Can we bring, if you'd like, I'll bring up the affidavit for you to look at.
No, I don't think these are business records.
You can't put a business record on something that is, you can't make a co-conspirator statement admissible or whatever through a business records affidavit.
Yeah, I think that's true because it's a different level of it's a different level of the hearsay analysis. Also, I'm not sure they're business records within the meaning of business records because they aren't created by the AG's office. They're received by the AG's office, but they aren't created by the AG's office in the ordinary course of the business.
As you said, Mr. Hardin, you didn't mean to spring this on the court at the last second, but it is to us at the last second. I think this is a good time for a lunch break.
Sure.
And to give us a chance to review all of this.
And just for your edification, Mr. President, I think the majority of these, I think, Rusty, correct me if I'm wrong, but I think the ones we're objecting to are very similar to, our objection to these is going to be consistent with the majority of the other ones that you want in, right?
That was going to be my next question, is the objection on all of these
I don't
the
know
same?
all of them, but most of them.
Most of them.
Yeah, his objection would cover those, and our response covers all those that were kept out in his records.
Okay.
Thank you.
We may reach out to you during the lunch break. We may not, but we'll come back at 1 p.m. The witness can be excused till 1 p.m. You want to be back at 1?
Yeah.
And counsel, can you both come up before you all leave for lunch break?
So yeah, it's interesting because it's a statement of a co-conspirator, right? So the allegation is the conspiracy. He's in a conspiracy with these people. They're providing statements to them. So it's like it's coming from Paxton. So it's a statement against interest by a co-conspirator. It's not really a business record because it wasn't produced or generated by the AG's office or even Mr. Kamek. It was produced by Wynn, I think, if I understood it correctly. So Wynn is the one submitting it to him. So business record isn't correct. Right, it's received in the course of their business, but it's not generated by the AG's office, so it's not a business record. It's a record by a co-conspirator. Interesting. I'm trying to remember my finer points of like co-conspiracy law when it comes to such issues. Yeah. Good legal question, though. Okay. So, yeah, I think admissible. I think it's admissible would be my best analysis. Yeah, because it's a statement by a co-conspirator. He's in the conspiracy with them. That's the allegation. So it's a statement by a co-conspirator, so it's admissible to prove the conspiracy. Yeah. Don't join conspiracies, kid. You know? Yeah. So that's where we're at right now. That's where we're at right now. So I think it will be admissible. But we'll see what they say when they come back, I guess. Okay. What conspiracy? The conspiracy was to further Mr. Paul's interests. So Mr. Paul, his lawyer, and the Attorney General were in a conspiracy to turn over his office to Mr. Paul. And so Mr. Paul would be part of the conspiracy kind of by definition, and his attorney makes logical sense to some degree as being part of the conspiracy. So that would be the conspiracy. Sounds a little like RICO. I mean, conspiracy is RICO. RICO is just a special kind of conspiracy. But yeah, RICO, it's a little bit like RICO because conspiracy is a little bit like RICO. RICO is just conspiracy law on steroids. The witness is not a conspirator, that's true. But it doesn't have to be. It's a statement from a conspirator. So it was received. The allegation is that he received the right. If he's an unwilling dupe, he's not part of the conspiracy. That makes sense, right? From first principles. So if you don't know that you're part of the conspiracy, you can't be like criminally responsible for the conspiracy. You're just an unwilling dupe helping along. So the idea is he's an unwilling dupe. Okay, so he's not part of the conspiracy. But he's receiving statements from other members of the conspiracy. So the statements are statements against interests by members of the conspiracy. which is a statement against interest by Paxton because he's part of the conspiracy. So yes, he's not part of the conspiracy, but it doesn't have to be. He's reporting on things that he received, and it's not hearsay. It's a statement against interest by a co-conspirator. Tell that to the Jan 6ers in prison that didn't go into the building. I don't know what you're referring to. I don't understand what you mean. I don't get it. You have to understand. I don't know what they're being charged with. And you're talking about all the Jan 6ers in Broad? I don't know. What are you talking about? Some of them may be guilty of conspiracy. Some of them may not. Some of them may be guilty of other things. I don't know. Which Jan 6ers? As respect to what? I don't know. Each case has to be evaluated unto itself. You know that. So are all the Jan 6ers guilty of conspiracy? Probably not, no. Because not all of them necessarily entered into an agreement. Although they might have, depended on other factors. But, like, that's a ridiculous thing for me to say. I can't possibly adjudicate all the Jan 6ers in gross. That's ridiculous. I have to look at each case unto itself. Even ones that didn't go in and were charged with seditious conspiracy. Right, you don't have to go in to be charged with conspiracy. That's correct. The conspiracy is the agreement. And all you need is one of the conspirators to commit an overt act. The hand of one washes the hand of all. So if one of them goes in, they all go in. That's the nature of the conspiracy. Don't join conspiracies. The hand of one is the hand of all. Everyone is guilty for everything. That's the nature of conspiracy. So if you enter into an agreement and one of your co-conspirators does an illegal thing in furtherance of your illegal agreement, congratulations, you're all guilty of that thing. You all did the thing because you're part of the conspiracy. Don't join conspiracies. Conspiracies are stupid. Karen O says no signs are posted. I don't know, Karen. I'm not here to... What do you want from me? What do you want from me? I don't know. I'm not here to adjudicate every... What do you want? I'm not here to adjudicate every possible Jan 6 case. That's ridiculous. What are you trying to get me to do? Trying to make global statements about all Jan 6ers? That's ridiculous. Every case has to be understood under its own terms. Were there signs posted? I don't know. Is that legally required? I don't know. What are they being charged with? Right? I don't know the answer to the question. So, like, you're giving me a piece of information saying, okay, there were no signs posted. It's like, maybe, is that legally operative? I don't know. What's the nature of the charge? What do you want from me? You know? What do you want from me? No signs were posted? Okay, I'll take your word for it. I also don't know what that means. Also, I believe that there was a fence, and the fence formed a barrier, so I believe people broke through fencing, and that would be a fact that is relevant. So I don't know whether there are signs posted. I think there were on the fences, as I seem to vaguely recall, although it's been a while. I believe there were signs posted on the fence. So I think you might be factually incorrect as well. But it's been a while. Let's see. KM said, when the lions sleep tonight, they dream of Kurt. Well, thank you very much. That's very kind. Bike Dance says, there's no sign at my house, but people can't just come in. That's true, too. Yeah. Jim says, isn't foreknowledge a necessary element? A necessary element of what? With respect to whom? Under what circumstances? You know? You seem to want me to provide like these global adjudications. I can't really do that. I have to look to each case unto itself under its own merits. I don't know. Some of them may be guilty, some of them may not. I don't know. Some of them may be guilty of some things, some of them not guilty of other things. I don't know. I don't know. In the like 50 of them or so we covered as part of the Capitol Riot series, when we were covering them, I can say that the FBI and Department of Justice had prima facie evidence with respect to every element we looked at, except in one case. And only in one case out of the 50 or so that we reviewed, I'm like, I don't think the DOJ has a prima facie case. But in the other 49 or whatever we reviewed, or 50 or 54 or whatever it was, I'm like, yeah, they have a prima facie case as to the cases they're being charged with. But are there defenses beyond that? I don't know. Right? It's like, I don't know if there were defenses beyond that. I don't know if all of them were necessarily valid. I can say that there was a prima facie case, which was all I was trying to evaluate when I was doing that series. It's like, it's just not fair to me to ask me to try to adjudicate Jan 6 as some sort of global thing. To the extent you want me to adjudicate Jan 6 in a global way, then all I can really say in a global sense is that it was a riot. And people were engaging in riotous, disruptive behavior and disrupted the function of the U.S. government in conducting a lawful function. So to the extent you want me to make global statements, they are globally guilty. Does that make you happier? That seems a little bit unfair to the individuals involved, but if you really want me to make global statements, I guess that's all I can say, globally. I'm also not sure how it relates to anything on this case. That's also very fair. I am not looking it up, Karen. We are moving on. A bike rack isn't enough? Bullshit. I'm not looking up the Federal Register. I'm not adjudicating the finer points of this right now. That is not fair to me. I don't really want to do that right now. You're not being fair to me. I hate you. We are moving on. We are moving on. I don't know if you're a glowy trying to like trick me into something or whatever. I don't also care. Either way, I'm going to give you the best legal analysis I can. Some of them may be guilty. Some of them may not. Some of them may have defenses. You may even be right with respect to particular of them and particular charges. I don't know. You may even be right. I don't know. I'd have to look into each individual case with respect to their particular knowledge and what they did or did not know about and their specific vantage point, which is something we talked about earlier when we talk about vantage points and making sure that we look at it from each particular person's vantage point, because each particular person's knowledge is a little bit different. Each particular person's information is a little bit different. Each particular act is a little bit different. We have to look at it in a particularized, individualized way as to each particular person and what they did or did not know with respect to each particular person. So I don't know if you're trying to get me to like trip up or something or say some sort of thing, but like I don't know what your motivation is, and I don't really care. All I can really say is that with respect to particular defendants, they may or may not have defenses as to some of the charges. I don't know. Some of them may very well not be guilty of some of the things they were charged with. I don't know. I'd have to look into the particulars. The only thing I can globally say is that globally there was a riot. Globally, they were engaged in disruption of an official process, a constitutionally mandated process, incidentally. And globally, they are guilty. So that's all I can really say. As to the individuals, I don't know. Beyond that, I don't know what you want from me. You're obviously not going to get the answer you want, so I don't know what more I can do for you. But that's where we're at. Anyways, I'm signing off for now. If you've enjoyed this stream, which somehow turned into a Jan 6 discussion somehow, I'm not even sure. But if you've been enjoying the stream, please remember to like it. I'm going to go get some lunch, and we'll be back in about 40 minutes or so, give or take. Until later, my friends, I'll see you all later. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.